rule of law, separation of powers, natural justice, judicial review, the executive, the legislature, the judiciary, the minor organs, right? And we are going to treat all these particular and relevant topics, as well as, chieftaincy, commissions of inquiry, citizenship, human rights. So I'll be taking you through the sessions for today. And because it's quite packed, constitutional law is quite packed, I'll move a bit fast. And I would also like to have your patience. Let me just complete a number of sessions, then you can take questions and you can move on. I hope you got it. All right, so thank you. So let's start with the first topic. I'm starting with constitutional supremacy and enforcement. And what I'm going to do is to take you through, what constitutional supremacy and enforcement stands for. Anytime you are answering a question, especially a problem question on constitutional law, there is this underlying matter, whether or not a particular action or omission or a law that has been passed is, constitutional, or it breaches the provisions of the Constitution. So with respect to constitutional supremacy, we are going to trace our authorities from, first of all, Article 1 of the 1992 Constitution. So the famous Article 1, it says the sovereignty of Ghana resides in the people of Ghana, in whose name and for whose welfare the powers of government are to be exercised in the manner and within the limits that are laid down in this Constitution. So this means under Article 1, Clause 2, the Constitution shall be the supreme law of Ghana, and any law that is found to be inconsistent with any provision of the Constitution shall, to the extent of the inconsistency, be void. I love cases because for constitutional law, there are a lot of challenges based on this particular provision. A lot of actions have been taken to the Supreme Court under Article 2, Clause 1, where the party sought to enforce the provision of the Constitution. So that's what it stands for, especially looking at constitutional law. It deals with what? The Constitution. So the major question you are going to be asked under constitutional law, what is likely to come, is whether or not a law or an action or omission is consistent or inconsistent with the provisions of the Constitution. And it can come in many forms. If it's an easy question, then they could talk about various other topics, like you could address a particular topic sentence. But as long as there is a problem question dealing with the Constitution, we are going to compare an act or omission or a law to determine whether this act or omission or law is consistent with the provision of the Constitution. So your Article 1, Clause 2, as long as it is on constitutional law, right, the problem question, as long as you are using IRAC, pay attention to Article 1, Clause 2 and Article 2, Clause 1. So Article 1, Clause 2 provides that the Constitution shall be the supreme law of Ghana, and any other law that is inconsistent with the provisions of the Constitution shall, to the extent of the inconsistency, be void. So in this case, we are dealing with a law. Any other law that is found to be inconsistent with the Constitution, then you need to pay attention to Article 11. Article 11 provides us with the sources of law. It says, under formal sources of law, we have the Constitution, number 1, followed by the statute, number 2, followed by the subsidiary legislation, and then we also have what is known as the existing law and the common law. So that means that when Article 1, Clause 2 said any law that is inconsistent with the provision of the Constitution shall, to the extent of the inconsistency, be deemed null and void, they are talking about the laws that are found in there, including common law. That includes customary law, equity, and then common law, that is the precedent. So you need to be able to identify particular authorities that support this principle, because Article 1, Clause 2 is focusing on law. So once you raise Article 1, Clause 2, we are dealing with a particular law. It says any law found to be inconsistent with the Constitution. So for example, we are going to start with the case of Martin Pebu and Attorney General, right? It is a case for the enforcement of the supremacy of the Constitution. And there are a number of cases that Martin Pebu brought to the Supreme Court, right? So we are going to use two cases, Martin Pebu and Attorney General. This particular case is known as the non-bailable offences case, right? So in this particular case, okay, let's use the there's another one. So I'll come to the non-bailable offenses case. Let's use the 48-hour rule case. Right. So with respect to the 48-hour rule case, you know what's happened, right? Under this particular case, in respect of the Public Holidays Act, it stated that during holidays, right, the courts will not be in session. So the courts will not sit during holidays. And during weekends, too, the court wouldn't sit. That was the previous rule under the Public Holidays Act. So you see, the Public Holidays Act is a law. Now, this law has a provision that directs courts not to sit on weekends and maybe on holidays and holidays too. Now, in this sense, what it meant was that when a person was arrested under Article 14 and the person was supposed to be brought before the court within 48 hours, they weren't counting what holidays and weekends. But then Martin Pebu brought the action to the Supreme Court and he made reference to Article 1, Clause 2, which says that any law that is found to be inconsistent with the provisions of the Constitution will be declared null and void to the extent of the inconsistency. And so what is the law here? The Public Holidays Act, a provision in the Public Holidays Act. Now, the court held that it will be unlawful to refuse to count holidays and weekends as part of the 48 hours. Right. 48 hours in the Constitution under Article 14 of the 1992 Constitution is 48 hours. So it's very straightforward. So it means we are dealing with a law that is inconsistent with the Constitution. Look at this other relevant case, Professor Epiaije Etua and Attorney General. Now, this particular case is usually referred to as the COVID case, where there was a particular law, it was the Imposition of Restrictions Act. The Imposition of Restrictions Act. Now, in this particular case, what happened was that Parliament passed the law known as the Imposition of Restrictions Act during COVID. That gave wide powers to the president, a lot of liberal powers to the president to declare lockdowns, and make certain declarations that will greatly restrict our freedom of movement. Now, the grounds for restricting our freedom of movement is provided for under Article 21 of the 1992 Constitution. Article 21 of the 1992 Constitution. And so with respect to that, and also Article 12, you cannot restrict those essential rights and provisions unless you fall under the exceptions to our freedom of movement and Article 21 of the 1992 Constitution. And also, you must first of all declare a state of emergency before you can exercise those emergency powers. So when COVID happened, there was no declaration of a state of emergency. I hope you got it. And the court held that since there wasn't any official declaration of a state of emergency under Article 31 of the 1992 Constitution, that Imposition of Restrictions Act was null and void. The entire law was null and void. You get it? So first of all, a provision in the law can be inconsistent with the Constitution. And then also the entire law can be inconsistent with the Constitution. Now, as I said, there are other sources of law. What about an existing law? An existing law is a law that came in force before the 1992 Constitution. And under Article 11, the existing law can be modified or amended to conform with the 1992 Constitution. Why? Because the 1992 Constitution is the supreme law under Article 1 Clause 2. Now, with reference to the existing law, right, what it means is that where existing law isn't in conformity with the provisions of the Constitution, it will be declared null and void to the extent of the inconsistency. So let's use another good example. So I'll make reference to the case of Martin Pebu again and Attorney General. This is dealing with the non-bailable offenses under the Criminal Procedure Act 1960, Act 30. So now the Criminal Procedure Act 1960, Act 30 provided that there are certain offenses that are non-bailable offenses. This means that with these particular offenses, you will not have the right to even apply for bail. They included murder, manslaughter, armed robbery, rape, and many others, treason, etc. So this means that in 1960, when the law was passed up to 1992, that was the opinion of law, or that was the law that certain offenses you could not grant bail for certain offenses, right? So Martin Pebu brought an action to the Supreme Court for a declaration that this particular existing law that came before 1992, right, is inconsistent with Article 14 of the 1992 Constitution. So when he provided that, look, there is no such thing as non-bailable offense because Article 14 guarantees our right to bail. and the court agreed, that means that that particular section in the existing law was struck out as null and void. Then it opened it up for us to, generally state that now everyone is entitled to bail. Everyone can enjoy the right to apply for bail. I hope you got it. Right. That is very straightforward. So the point is that it can be a law, it can be a provision in the law, it can be an existing law, right? So any statute that does not conform with the Constitution will be declared null and void. Look at the case of NPP and IGP. It was also a law. This particular law was the Public Order Act. And the issue was that under the Public Order Act, you needed the permission or the license from the IGP before you could embark on demonstration. So with respect to the Public Order Act, right, with respect to the Public Order Act, if you didn't ask the IGP for permission, or if they refused a permit, you could not embark on demonstration. Now, NPP brought an action that it is an infringement of Article 21 of the 1992 Constitution that guarantees our right to go on demonstrations and lawful protests. This is the freedom of assembly under Article 21. Therefore, any law that provides that you need the permission of the IGP before you be permitted to embark on a demonstration was unconstitutional. And that was what the court held to, that provision is inconsistent with the 1992 Constitution, therefore null and void. So I'm letting you know that yes, we have the locus classicus case of Tufo and Attorney General, but that case didn't deal with a law. There are lots of other cases that dealt with laws. Any law that is inconsistent with the 1992 Constitution, it can even be a legislative instrument or a constitutional instrument. For legislative instruments, look at the case of Mensima and Attorney General. I've explained that case in some of the materials, right? In Mensima and Attorney General, it was a legislative instrument that stated that you are compelled, you must join an association before you can apply for a license to produce local alcoholic beverage, like their petition, all that. Right? The court held that that is in breach of Article 21 of the 1992 Constitution, right? Our freedom of association. So it's very straightforward. This means that any law, it can be in the form of an LI, a CI, like the case of Supremacy, an Attorney General, and Electoral Commission, right? Any law that is inconsistent with the provisions of the Constitution will be declared null and void to the extent of the inconsistency. Now let's have a look at the next one. Article 2, Clause 1. It says a person who alleges that an enactment or anything contained in or done under the authority of that any other enactment, or B, any act or omission of any person is inconsistent with or is in contravention of a provision of this Constitution, may bring an action in the Supreme Court for a declaration to that effect. So that is dealing with the enforcement of the Constitution. So here it says any person can bring an action to the Supreme Court for a declaration that what a particular law, that is an enactment, or anything done under that particular enactment, or any act or omission of any person is inconsistent with the Constitution. Now, in Article 2, Clause 2, it says that the Supreme Court can also give such orders and directions as it may consider appropriate for giving effect to or enabling effect to be given to the declaration. Now, it means that first of all, we have to identify who is a person under Article 2, Clause 1. A person under Article 2, Clause 1 can be either a natural person or an artificial person, but that person must at least be a citizen of Ghana. This was stated in the case of Tufo and Attorney General. The landmark authority for the enforcement of the supremacy of the Constitution is Tufo and Attorney General. And I'm sure you've heard of that particular case. So in this particular case, the court held that what a person who can bring an action is a Ghanaian citizen, because every Ghanaian citizen has an interest and has an obligation and a responsibility or a duty to defend the Constitution at all times. So that person has an interest in ensuring that nothing done is inconsistent with the provisions of the Constitution. So that was provided in that particular case of Tufo Attorney General. So it can be a natural person under Tufo Attorney General, and it can also be an artificial person. Artificial person can be a political party or a company or a particular group. So, for example, we can have an NGO, right, that can bring an action, or a civil organization that can bring an action, right? Remember the case of Center for Democratic Development against the Attorney General. In this particular case, when the Auditor General was directed by the president, the former president, Nana Akufo-Addo, to go on mandatory leave, they brought an action claiming that it is inconsistent with the independence of the office of the Auditor General. And the court held that, yes, this particular directive to go on mandatory leave is inconsistent with the independence of the office of the Auditor General. So that is, enforcing the supremacy of the Constitution and Article 2, Clause 1. So it can be a civil society or an NGO. It can also be a political party. Look at the case of NPP and Attorney General, the 31st December case, when there was a declaration, right, that those the particular executive at the time, led by President John Rawlings, will celebrate 31st December, right, with public funds to commemorate or to celebrate the coup d'etat, the 31st December coup. NPP brought an action to the Supreme Court as a political party. So it wasn't a natural person, it was an artificial person that brought an action to enforce the supremacy of the Constitution, specifically Article 2, Clause 1, Article 3, Clause 4 of the 1992 Constitution. They claim that a coup d'etat amounts to treason under Article 3, Clause 3, and any person, any Ghanaian citizen is under a duty to enforce the Constitution at all times under Article 3, Clause 4. So with respect to that, what the law meant was that any action which was inconsistent with the supremacy of the Constitution could be declared null and void. And the court held that, yes, celebrating a coup with public funds was inconsistent with Article 3, Clause 4. That is the spirit of the Constitution, the underlying meaning of Article 3, Clause 4, which places an obligation to what? To defend the state against any future acts of treason. That is a coup d'etat. So that means that if you are under a duty to defend Ghana from any coup d'etat, then you cannot be celebrating coup d'etat with public funds. So that was the decision in that particular case. Very straightforward point. So you realize that under Article 1, Clause 2 and Article 2, Clause 1, we have a lot of prominent cases. Martin Pebu and Attorney General, Professor P.I.J. Etienne Attorney General, Tufoyn Attorney General, MPP and IGP, right? We also have cases like Mensima and Attorney General and many more. So under Article 1, Clause 2, under Article 2, Clause 1, any person can bring an action, but it cannot be a foreigner. It is only a Ghanaian citizen. So that Ghanaian citizen can also be a dual citizen. A dual citizen. A Ghanaian citizen can also be a dual citizen. So there are three dual citizens. There are three cases in reference to the dual citizen. The dual citizen I'll be referring to is Professor Asare. Professor Asare is a professor that is not based in Ghana, but he's a dual citizen. He's also Ghanaian. So he has brought a number of constitutional actions to the Supreme Court. The first one, or one of them, was Professor Asare and the Attorney General. This is known as the swearing-in case. In this particular case of Professor Asare and the Attorney General, that is the swearing-in case, what basically happened was that under Article 60, Clause 11, it was declared that when the president and the vice are unable to perform their functions under the Constitution, right, they will be replaced by the speaker who is swearing the oath. So now the issue was that when the president and vice left Ghana at the same time, the speaker came to swear in the oath to sit in the position of the president. Professor Asare brought an action claiming that it is unconstitutional because when the president and the vice are out of Ghana performing the duties of the president and vice, it doesn't mean that they are unable to perform their functions, so they should be replaced by the speaker. In fact, they are actually performing their functions and representing Ghana abroad. So that means that they are still performing their mandate and cannot be replaced by the speaker. But the court held that when the president and vice are out of the country, right, there is no representation of the executive in Ghana. And from our prior history, we know that the representation of an executive power, right, with respect to him being the commander-in-chief of the armed forces and he performing ceremonial roles of the president is so important. Usually, it's a temporary measure to ensure that at all times there is an executive authority in Ghana, especially if any state of emergency or anything pops up. So in that particular case, the court held that it was constitutional for the speaker to be sworn in, although there was nothing wrong with the president or vice, and they are just traveled outside the country for the performance of the ceremonial functions or to represent the state. Even if technology can connect the president to Ghana, enable him give directives and orders, at least we still need the representation of the executive in Ghana. So that's the case of Professor Asare and Attorney General, the swearing-in case. There's also another Professor Asare case. This particular Professor Asare case is called Professor Asare and the Attorney General, the dual citizenship case. I'll come to it again under Article 8 of the 1992 Constitution that deals with dual citizenship. So under Article 8 of the 1992 Constitution of Ghana, right, when you are a dual citizen, right, you are not entitled to occupy certain offices. Like you cannot be an ambassador, right, or maybe you hold certain offices that are connected to national security and all that under the Constitution. So in that sense, what basically happened in this case was that he brought an action claiming it was unconstitutional. It was unconstitutional because why are they making such restrictions against dual citizens? Dual citizens are also Ghanaians. But the court had to explain the distinction between being a Ghanaian and owing allegiance to Ghana. You can be a Ghanaian because you are born to Ghanaian parents and you are a dual citizen, but it doesn't necessarily mean that you owe allegiance to Ghana. If you are Ghanaian and also an English or a British, right, or an American, right, so you have dual citizenship, or you're a Canadian, there's a very strong inference that you can still owe allegiance to the other country. In fact, you're very likely to owe allegiance to those other countries other than the state of Ghana. So it means that any office that deals with the person having strong allegiance to another, any office that deals with the person needing to have strong allegiance to Ghana would amount to what? An office that cannot be occupied by a dual citizen. This was enforced also in the case of Michael Nimfa and James Chachi-Quayson. Do you remember that case? Where it was held that under Article 94, a person cannot be qualified to be a parliamentarian if that person owes allegiance to a country other than that of Ghana. And the court actually held in that case that being a dual citizen implies strongly that you owe allegiance to another country other than that of Ghana. And so a dual citizen cannot be a Ghanaian parliamentarian. I hope you got it. That is just very straightforward. So you quickly move on to the next one, right? So now we've dealt with Article 2 Clause 1. I also said that it can also be a dual citizen, right? So the dual citizen, I gave two Professor Asari cases. The third one is Professor Asari and the Attorney General, the CRC case. That's the Constitutional Review Committee case. I hope you got it. Right. So let's quickly move on. Now, remember, if the Supreme Court gives an order and you don't abide by the decision of the Supreme Court, that will constitute high crime under Article 2 of the 1992 Constitution. And with reference to high crime, the president or the vice president can be immediately removed from office or impeached. I hope you got it. And any other person can suffer imprisonment not exceeding 10 years without the option of a fine and not be eligible for election or for appointment to any public office. So that is it. Now, let's quickly look at certain important matters dealing with the enforcement of the constitutional supremacy. Right. Now, the enforcement of the constitutional supremacy is vested in the court, the judiciary. You know, the judiciary is vested with authority under Article 125 of the Constitution. But under Article 126 of the 1992 Constitution, there are three superior courts. We have the High Court, we have the Court of Appeal, and we have the Supreme Court. We have the High Court, we have the Court of Appeal, and we have the Supreme Court. So the High Court, right, enforces fundamental human rights. The High Court enforces fundamental human rights under Article 33 of the 1992 Constitution. This means that when there is an action where a person has been personally aggrieved by a breach of his fundamental human rights, either any of them under Chapter 5 or any fundamental human rights that is provided for, right, the person can bring an action quickly to the High Court for a relief. So this means that you do not take the action to the Supreme Court, right? Because it deals with Article 33, that is fundamental human rights breach in the personal against the personal interest of the person, right? However, if the matter is in the public interest, even if it's a human rights matter, but it is in the public interest, then you take it to the Supreme Court. So what is the structure? The structure is that when we are dealing with the enforcement of the supremacy of the Constitution, is that you start from Article 1 Clause 1. The Constitution is vested with the sovereignty of the people. Article 1 Clause 2, the Constitution is the supreme law. Article 2 Clause 1, then you move on to Article 2 Clause 2, and then, explain high crime. Then, as I also said, right, under Article 33, the High Court enforces the human rights provisions of the Constitution. So although it says that the person can take the matter to the Supreme Court, it is only when the matter affects the public interest and it affects the public interest. That's when you take the matter to the Supreme Court. But when you are personally aggrieved, especially when it's a breach of your human rights, You take that particular action to which court? The High Court under Article 33 of the 1992 Constitution of Ghana. And then you make reference to Article 295 that explains public interest. The public interest is anything that inures to the benefit of the state. This was applied in the compulsory acquisition cases, right? Two major cases, that is the Ni Probitatetu and Attorney General, right? And then we also have the case of Samoku Jeto and Attorney General. I dealt with those cases when I was dealing with compulsory acquisition under immovable property law, but we also deal with them later under compulsory acquisition in Chapter 5 of the 1992 Constitution, specifically Article 20. So we'll come to public interest later. But public interest is anything that inures to the benefit of the public. So Article 33 clause 1 is saying that when you are personally aggrieved, you take the matter to the High Court to enforce the Constitution. But when it is a grievance in the public interest, then you can take it to the Supreme Court. This was enforced in the case of Sam number 2 and Attorney General. So he brought an action claiming that a particular law is inconsistent with the Constitution. The Attorney General argued that he wasn't affected by that particular law. The court held that although he is not affected by that particular law, he is a Ghanaian. And also, the law is a law that is inconsistent with the Constitution. So it's affecting the public interest. It's not to our benefit. So you could bring the action in the public interest to strike out that particular law. There is another case of Eduse and Attorney General. He challenged his freedom of the breach of his freedom of movement or the restriction on his freedom of movement under Article 21. He claimed that they had seized his passport. So he was suing for an order to what? He was suing for an order to return his passport to him. The court held that no, they cannot grant such an order because it is something that you are personally aggrieved. You should take it to the High Court. You cannot bring that matter to the Supreme Court for enforcement of your personal freedom of movement. You cannot bring such a matter to the Supreme Court because you are personally aggrieved. It is not, you are personally aggrieved. It is not a matter in the public interest. I hope you got it. Right. So that is very, very, very straightforward. So it's not a matter in the public interest. You are personally aggrieved. So under Article 33 and Article 130, that says that subject to the jurisdiction of the High Court in the enforcement of the fundamental human rights and freedoms as provided in Article 33 of this Constitution, the Supreme Court shall have exclusive original jurisdiction in all matters relating to the enforcement or interpretation of this Constitution, and b, all matters arising as to whether an enactment was made in excess of the powers conferred on Parliament or any other authority or person by law or under this Constitution. Right. So that is it basically under constitutional supremacy. So all matters relating to the enforcement and interpretation of the Constitution. We have this landmark case known as the case of Ex parte Acosta. Right. So in the case of Ex parte Acosta, the court held that there are four matters that will lead that will call for constitutional interpretation. The first one is where the words of the provision are unclear and ambiguous. Where the words of the provision are unclear and ambiguous. The second one is where the parties are having rival meaning to the same provision of the Constitution. Where the parties are having rival meaning to the same provisions of the Constitution. So the third one is where the party is claiming that an action or law was inconsistent with the Constitution. And the fourth one is where a party claims that a provision of the Constitution is in conflict with another provision of the Constitution. So more or less, you can find all the briefs of the cases, all the updated notes and recordings in the Google Drive, right? The alleged Google Drive. So there's a compilation of all the topics under constitutional law with all the notes and authorities and past questions for each principle. You get it. So what are we trying to determine? That in reference to the matter of the supremacy of the Constitution, you have to ask yourself, is there any law, act, or omission that is inconsistent with the provision? So whether or not this particular act is inconsistent with the provision, whether or not this particular law is inconsistent with the Constitution, pardon me, so with the Constitution. So whether or not this particular law is inconsistent with the Constitution, whether or not this particular act is inconsistent with the Constitution, whether or not this particular omission is inconsistent with the Constitution, then you have to give certain points to make the facts, the issue stand out. So whether or not the president directing the Auditor General to go on leave is inconsistent with the Constitution, whether or not the president, suspending the Chief Justice due to pending investigations from a committee based on a misstated behavior is inconsistent with the Constitution. Whether or not the president's removal of the Chief Justice is inconsistent with the Constitution. Whether or not the president's declaration for the celebration of coup d'etat is inconsistent with the Constitution. Whether or not the Imposition of Restrictions Act is inconsistent with the Constitution. Whether or not the family value bills, also known as the LGBT bill, is inconsistent with the Constitution. Whether or not the compulsory acquisition of the plaintiff's land was inconsistent with Article 20 of the Constitution. Whether or not this, whether or not that. So that is the first thing. You need to determine, especially if it's a problem question, whether there is an act or a law or mission that is inconsistent with the provisions of the Constitution. This is the foundation of constitutional law. So before you do that, so you need to determine whether or not the Supreme Court or High Court has jurisdiction in the matter. So probably we have to look at which court has jurisdiction in the particular matter. So if you are reading the question very well, you have to pay attention to the fact. Is it a matter where it deals with human rights? So what are the human rights of head? Say Article 12, General Human Rights Provisions. Article 13, that is the right to life, right? Article 14, that is the right to personal liberty. Article 15 is a freedom. What freedom does it deal with? What does it deal with? Right, freedom, right to personal dignity, pardon me. Article 16 is the freedom from slavery. I'm saying it off head. Article 17 is freedom from discrimination. Article 18 is the right to own property. Article 19, right, is what? Fair trial. Article 20 is compulsory acquisition. Article 21 is fundamental human rights. Article 22 is spousal rights. Article 23 is administrative rights. So if it's dealing with any those provisions I've mentioned and a lot more, all the way to Article 32, 33, or maybe the right to vote or something, if it's dealing with a person where he has been personally aggrieved in his fundamental human rights, he takes the matter to the High Court and Article 33 of the Constitution. Pay attention to these cases. Psalm number 2 and Attorney General. Eduse and Attorney General. AJ Ampofo and Attorney General. We also have the case of Queen Poputa against the General Legal Counsel. And then we have other supporting cases like Fediac versus public universities or so. You get the point. So there are a lot of cases in there. Then if you look at Article 2 Clause 1, who can sue? Whether or not the party has local standard to sue, it must be a citizen of Ghana. So a citizen of Ghana, right? Whether or not the party has local standard to sue, it must be what? A citizen of Ghana. So that's it. So that means that you can be a private citizen or what? It can be an artificial person or you can what? Be a natural person, right? Artificial person, you must be registered in Ghana. That is the rule. For an artificial person to be deemed to be a citizen of Ghana, that particular artificial person must be registered in Ghana. So that is the principle in there. Very straightforward. So pay attention to Article 1 Clause 2, Article 2 Clause 1, Article 130, that's the jurisdiction of the Supreme Court. Article 33, that's the jurisdiction of the High Court in the enforcement of the human rights provisions of the Constitution. Also pay attention to Article 140, that's also the general jurisdiction of the High Court. And you are good to go. Now you have to make sure that you have an idea of that particular provision of the Constitution that the facts will probably lead you to conclude on whether there is a breach or not. So you have to have a general idea of the relevant provisions of the Constitution. So because of that, we have to go through some of the important theories and doctrines of constitutional law. Let's go quickly before we come to the constitutional effect of coups and revolutions. Let's go quickly to some of the foundational doctrines. Now, let me give you this trick. This is what you must remember. Constitutional law, right, can be divided into 4 parts. So the first part is dealing with the theories or the doctrines. The theories or the doctrines of constitutional law. So some of the theories are constitutionalism or doctrines. So the theories or doctrines, right? Constitutionalism, rule of law, separation of powers, judicial review, natural justice. Are you getting the point? So those are theories. We also have the constitutional effects of coup d'etats and revolutions. Those are theories, right? Because they are proponents of those theories. The jurists, they propose certain theories and then we've applied it, we've moved alongside it. Then there are also what is known as human rights provisions. So either the question could deal with a theory of constitutional law or it could deal with the human rights provisions. For example, under human rights, Article 12, 13, 14, 15, 16, all the way to Article 33 and other human rights provisions in the Constitution. It could also deal with the Commission of Inquiry in the enforcement of human rights. Look at the case of Swatch against Swatch and the Ghana National Fire Service case. So Swatch v Ghana National Fire Service, a very important case, right? Look at administrative powers under the Constitution, like Awuni and Wayek, like Abuaji and GCP. I hope you got it. So there are certain relevant cases that are foundational, but those ones will deal with human rights. Then another aspect is what is known as the major organs. The major organs, the executive, the legislature, the judiciary. The executive, Article 57, it starts from there. The legislature, Article 93, it moves from there. The judiciary, Article 125, it moves from there. Now, separation of powers, right, rule of law, constitutionalism, they usually deal with the major organs. So when you read the question, you have to ask yourself, is it a major organ? Is it the executive? Is it the legislature? Is it the judiciary? How do they interrelate? Do you get it? Right? What are the checks and balances on those particular powers? Then now the last one is dealing with the minor organs, the office of the Auditor General, the office of the Attorney General, the office of SWAJ. We have also commissions of inquiry. We have the Council of State, right, and other councils set up in the Constitution. So these are relevant judicial organs, but they are minor organs. So that's what you need to know. So when you read the question, you're asking yourself, what is the topic sentence? Right? What is the topic sentence? And also, what is the area of law? You'll be able to determine. So now let's start with the theories of constitutional law. So pay attention to number 1, constitutionalism; number 2, separation of powers; number 3, rule of law; number 4, natural justice; number 5, judicial review; number 6, coup d'etat and revolution. So I'll quickly go through. I'll point out factors that are relevant, that every examiner expects the law students to know. These are the foundations to the particular doctrines or the theories. So let's start with number 1, constitutionalism. Right, let's move quickly to the doctrine or the theory of constitutionalism. Right, now constitutionalism, okay, basically means one thing, right? So, there are different words for it, but it deals with the restriction on governmental powers or the restriction on the exercise of governmental powers. So, it can also be a restraint, limitation, constraint on the exercise of governmental powers. I hope you got it. So, what are governmental powers? Governmental powers are basically the powers associated with the arms of government. That is the executive, the legislature, and the judiciary. If you pay attention to the Constitution, it makes it clear that the arms of government are also subject to the Constitution. So there are certain limitations. Now, people think that you have to start answering the question by determining the particular kind of restriction or restraints that they have, right? Or that is placed on the governmental organ. No, when you're answering a question on constitutionalism, either a problem question or an easy question, first of all, you need to establish what constitutionalism is. Constitutionalism is a restriction or a restraint or a constraint or a limitation on the exercise of governmental powers in the public interest. It is in the public interest. It is to protect the rights of the people. It is to ensure that governments do not act arbitrarily, and that the executive, the legislature, and the judiciary do not abuse the rights of the people. You know this. This is very fundamental. So if you don't explain it, then you can't start from anywhere. You have to start with telling or informing the examiner, right, or your marker what constitutionalism is, right? Then now you can move on to the types of limitations or restrictions or constraints or restraints, right? We have the institutional limitations, we have the substantive limitations, we also have the procedural limitations, the institutional limitations, the substantive limitations, and also the procedural limitations. So this is going to take us through a lot of provisions in the 1992 Constitution. So get ready. Now, institutional limitations. These are restraints or limitations that are set upon one organ by the other. Now, there are institutions that create limitations on other institutions. Now, it's like a form of checks and balance. So the way to limit the exercise of the executive power is to make the legislature or the judiciary or any other constitutional body or organ what provide a check or restrict the executive, right? So that is a limitation. It is a limitation by another institution. Simple. So institutional limitation is a limitation by another body that has been set up by the Constitution. Now, the body would have a privilege or a right or an authority to review the actions of the other body to determine whether or not it is constitutional. Now, it can come in many forms, but we'll come to that later. Then we do procedural restraints or procedural limitations. Now, when it comes to procedural limitations, right, this is not about, the core of it is not about institutions. The core of it is about the process, the means, the manner. I hope you got it. The process, the means, the manner. Check out Article 1, Clause 2 of the 1992 Constitution. It says, Article 1, Clause 1, pardon me. The supremacy of Ghana resides in the people of Ghana, in whose name and for whose welfare the powers of government are to be exercised in the manner and within the limits laid down in the Constitution. The manner and the limits. So when you start with constitutionalism, foundational principle, Article 1, Clause 1, the manner and the limits, limitations, that is constitutionalism. Limitations, constitutionalism, manner and limits. So the procedural limitations, that is the manner by which the organs or the bodies or the government should act. That is the process or the procedure by which they should act. So that means that the Constitution has outlined certain important processes and procedure by which the government should exercise their powers, such that a breach of the process or procedure makes the action null and void. It's as simple as that, right? So that is procedural limitations. And then we also have the third one. The third one is dealing with substantive limitations. So with respect to substantive limitations, you are looking at what? These are restrictions or limitations in and of themselves, right? They are not dealing with the means, they are just declarations that forbid the government from doing certain things. We will come to that, right? So now let's go back to the institutional limitations. Let's give examples for each. So institutional limitations, substantive limitations, procedural limitations. Let's give examples for each. So now let's start with the institutional limitations. A very good example is that although the president is the head of the executive under Article 57 of the Constitution, right? Under Article 78 of the Constitution, the president in the appointment of ministers must act what? With the consent of the legislature. So it means that the president will nominate the minister or the minister designate, and then what happens though? The minister will have to go through vetting approval. So the person, the nominee, will have to be vetted and approved by parliament before the person can, be called a minister or have the authority of a minister. So that means that one of the limitations on the authority of the president is that when the president is appointing a minister, he needs the consent of parliament. He needs parliament to approve that particular minister. So this provides a form of check. This ensures that the president does not abuse his powers in appointing too many ministers or people who are not fit for that particular job. Now, how Parliament will conduct the vetting is up to Parliament. This was explained in the case of J.H. Mensah, and Attorney General. I'm sure you've heard of this landmark authority, J.H. Mensah and Attorney General. So, with reference to the case of J.H. Mensah and Attorney General, what the court held was very, very, very straightforward. I hope you got it. Right, J.H. Mensah and Attorney General. Now, in this particular case, the ministers, the nominees, right, because they were reappointed by President Rawlings. So they stated that because they had come under Rawlings' first term, they don't need to go through vetting again. But the court held that no, they must be vetted again. I hope you got it. The court held that they must be vetted again. So in this particular case, it means that anytime there is a matter dealing with the appointment of the minister by the president, you need the consent or the approval of Parliament. Article 78, a very good example of the institutional limitation. It can also be a procedural limitation. So they move the appointment of the minister, right, by the president acting with the approval of Parliament. So vetting approval by Parliament, right? G.H. mentioned Attorney General. What about the appointment of the Chief Justice? So it says in Article 144, the Chief Justice shall be appointed by the President acting in consultation with the Council of State and with the approval of Parliament. So that is what the case of Ghana Bar Association and Attorney General, the Justice Aban case, where the court held that it is clear that the restriction or limitation is that in the appointment of Chief Justice, the President must consult the Council of State, and then the Chief Justice will be vetted and approved by Parliament. So there is consultation with the Council of State, and there's vetting and approval by Parliament. There are two Ghana Bar Association cases in here. We have the case of Ghana Bar Association and Attorney General, the earlier case known as Justice Aban case. In this particular case, the court held that once the Chief Justice was rightly nominated by the President after consultation with the Council of State, and once the Council of State, once Parliament has approved the Chief Justice, then the nominee, the person is rightly sworn in as the Chief Justice, even
Senior.
if the Ghana Bar Association does not believe that that particular
Also,
person has good character. Yes, you have a question.
I think there's
You have a question.
Please, if Sylvester Jan can, yeah, thank you.
Or is there an issue?
No, senior, everything is fine now.
All right. Okay, so let's continue. So now that is the Ghana Bar Association. Remember, the Ghana Bar Ghana Bar Association brought an action against the Attorney General, claiming that the appointment of Justice Aban was unconstitutional because Justice Aban is not a person of high moral character and integrity. But the court held that once the person was appointed following the constitutional process and the institutional limitations, then his appointment is valid. If you claim that he's not of high moral character and proven integrity, then bring a petition to the president for his removal under Article 146. Right, there's another case, Ghana Bar Association and Nene Amegache and others against the Attorney General. So in this particular case, it dealt with the appointment of Supreme Court judges, right, and certain other matters. Whether or not, more or less, the point I'm trying to convey to you from this case is that the court held that the president in particular is bound to consult the Judicial Council, but he's not bound by the advice of the Judicial Council. You get it? I'll come to the removal of judges later, especially when we are dealing with the independence of the judiciary. But also the removal of judges, there are certain limitations. So the removal of judges has a process. So that's a procedural limitation under Article 146. You can make reference to the case of Ejechum and Attorney General, the case of Honorable Justice Derry and Attorney General, and also the case of Honorable Justice Tokonu, Honorable Chief Justice Tokonu and Attorney General. Right, so those are the relevant cases in there. Now, another form of institutional limitation is the declaration of emergency powers under Article 31. So where the president declares an emergency power, what happens? He must refer the particular declaration to Parliament. I hope you got it. Right, within 72 hours for Parliament to either accept or revoke the declaration. So yes, when there's a state of emergency in Ghana, the president will first of all have to declare a state of emergency. And within 3 days, he has to present the information, the declaration with the that has been gazetted with all the relevant reasons for the state of emergency. He must provide it to Parliament, and within 72 hours, right? So Parliament can either decide to accept or reject it. So that was the point in there. Then you can look at the case of Professor Epiaje Etua and Attorney General. So it deals with what? The fact that the president did not declare a state of emergency, but Parliament quickly passed the Imposition of Restrictions Act during COVID to give the president the power to impose serious restrictions on us. Now let's have a look at another limitation. Article 106 can be a procedural limitation. It can also be an institutional limitation. Institutional because the process, right, needs working together or consultation with other groups. For example, when you are going to pass a law affecting chieftaincy, you have to consult the National House of Chiefs under Article 106 Clause 3. The case in point is the case of Wari and Ofori-Atta. Wari, Ware versus Ofori-Atta. So in this particular case, what happened was that a law was passed affecting chieftaincy, but in the process of passing it, they never consulted the National House of Chiefs. The court held that that particular law is void and unenforceable. Very, very straightforward case. Now, also, as I said, it can be institutional limitation because although Parliament has the authority to pass laws under Article 93 and Article 106, the laws must be assented to by the President. So this means that when Parliament pass the bill, they must present the bill to the President under Article 106 Clause 7 of the 1992 Constitution, and the President shall, signify within 7 days whether he assents to the bill or refuses to assent to the bill, unless he has referred the bill to the Council of State under Article 90 of the Constitution. Now, look at these two important cases: Amanda Odoi versus the Attorney General, and also the case of Richard Sky and the Attorney General. Now, both cases deal with a particular bill. This particular bill is known as the LGBT bill, the Family Values Bill. Now, this bill was presented to Parliament, right, for approval, and Parliament will vote on it. And then, if it's assented to by the President, it becomes law. Now, under Article 108 of the Constitution, right, where a bill affects the consolidated fund, it must be what's presented by the President or a delegate or a minister acting under the authority of the President. So Amanda Odoi claimed that this bill was introduced by a single member of Parliament. So it is a private member bill. And when this bill was brought by a single member of Parliament, right, it affected the consolidated fund. But the court held that no, the bill cannot be questioned in the Supreme Court because a bill is not a law. A bill is just a material source. I hope you dealt with sources of constitution, where you look at the formal source, the legal source, the material source, and the historical source. And I've had meetings and lectures where I told students how to answer questions on sources of law. Right? It's a very, very detailed and very probable question, and it came in the past exams some 4 or 5 years back, and students really flopped in that particular question because they answered it in a certain way. So probably later on I'll touch on that when I'm dealing with sources of law and Article 11 of the 1992 Constitution of Ghana. Right, all this a Ghana legal system question or area of law. It also deals with Article 11, that's in the Constitution. Right, now the point is under Article 106, right? And if you look at Article 2, Clause 1 and Article 1, Clause 2, it must be a law or an enactment. A bill is not a law or enactment. That means that the bill must be assented to by the President, right? And then it can become a law that you can question before the Supreme Court. If you bring a bill to the Supreme Court, you have not completed the process and you've acted prematurely. It was enforced in the same case of Richard Sky and Attorney General. It was also challenging the law. The court held that a bill is not an act of Parliament. A bill is not an enactment. A bill is not a law that can be challenged before the Supreme Court under Article 1, Clause 2 and Article 2, Clause 1, right? And Article 130. It must be an enactment or anything done under an enactment. So if you are claiming that a law is inconsistent with the Constitution, right, that law, that is the statute, must be assented to by the President. So since the bill was not yet assented to by the President, it is not law. You get it. So there are some procedural, this is also a procedural limitation because it deals with the process of lawmaking and Article 106. Remember the process of lawmaking. First of all, it must be a bill accompanied by an explanatory memorandum, published and gazetted and introduced before Parliament. Now, the point of explanatory memorandum, have a look at this relevant case, a very, very, very important case, Ezwame Manan and the Attorney General. In this particular case of Ezwame Manan and the Attorney General, what happened was that the law was passed, that is the Narcotics Control Act, right, was passed by Parliament. Now, the issue was that when the bill and the explanatory memorandum was presented to Parliament, right, it ended at, I think, up to Section 41. But Parliament decided to include a new section, that is Section 42. And when Parliament included Section 42, they stated clearly they didn't add the explanatory memorandum. They didn't give an explanatory memorandum would tell us the purpose or the reason for that particular provision. So they didn't add the explanatory memorandum. So they didn't give us the reason for the bill. I hope you got it. They didn't give us the reason for that particular addition. I hope you got it. Right. They didn't give us the reason for that particular addition. So in that particular sense, since that provision was not accompanied by an explanatory memorandum, it must be struck out as null and void. Ezwame Manan and Attorney General. If you are also voting to pass laws, you must make sure that you fulfill the quorum for voting in Parliament. Right, that is the case of what Justice Abdullah and Attorney General. So I've just spoken about the procedural and institutional limitations. That usually it is a process, and the process can involve one or more institutions. For example, the process of the appointment of a minister, Article 78, that is DH Mensa and Attorney General. The process of the appointment of a Chief Justice, that is Article 144, that is the case of Ghana Bar Association and the Attorney General. The process of what? Passage of international law and Article 75, Margaret Banfo and Attorney General, that is the Landmark Authority. So it is also a process under Article 75 where a treaty or a law is signed by the president abroad. That particular treaty or law must be presented before Parliament for ratification. So this was the Guantanamo Bay case, whereby two presidents under a treaty were sent to Ghana to mix up with society. The court held that this particular treaty was not brought before Parliament for ratification. So the treaty is struck out as null and void, although the time period has even passed, right? Because at the end, the treaty had already taken effect, had been exercised, and had expired. You get the point. But the court still declared that the treaty was unconstitutional because it was never ratified by Parliament. That is in accordance with Article 75 of the Attorney General. Pay attention to the case once again, the case of Margaret Banfo and the Attorney General. Very, very, very important case. So you quickly move on to another relevant authority. So apart from Article 75, we also have Article 11, Clause 7 of the 1992 Constitution. There's a process of lawmaking. That Article 11, Clause 7 deals with what? The passage of subsidiary legislation. Now, the subsidiary legislation and Article 11, Clause 1 are the constitutional instruments, the legislative instruments, and what is also known as the executive instruments. So I'm going to give you three important cases. The first one is dealing with a legislative instrument. The legislative instrument, that is the Mensima case. The court held that the legislative instrument was inconsistent with the Constitution. Right, the court held that the legislative instrument was inconsistent with the Constitution. I think someone is unmuted. Right, the court held that the legislative instrument was inconsistent with the provisions of the Constitution. Therefore, that particular section or part of the instrument was struck out. It was an infringement on our freedom of association. I hope you got it. Right. And then there is also another case for constitutional instrument. You can have the case of Supremacy and the Electoral Commission. The court held that in the passage of this constitutional instrument, Parliament did not comply with Article 11, Clause 7. That is the procedural limitation under Article 11, Clause 7. So what does 11, Clause 7 say? It provides that when you are passing a subsidiary legislation, like such as a legislative instrument or a constitutional instrument which is legislative in nature, you have to ensure that it is presented to Parliament and published in the Gazette, right? It's presented to Parliament for 21 sitting days, and at the end of the 21 sitting days, Parliament will vote to either accept or reject the law. Now, in this particular case, the Electoral Commission brought a constitutional parliament and a constitutional instrument to Parliament under Article 11, Clause 7. What basically occurred was that Parliament decided to amend the constitutional instrument and then passed it. In that sense, the court held that this was an infringement of Article 11, Clause 7 of the 1992 Constitution. So the case in point is the case of Supremacy versus the Electoral Commission, the Premier and EC. Right, that's the major case. So now we've dealt with a lot of cases, right, that deal with a lot of cases that deal with the substantive and then that deal with the procedural and also what is known as the institutional limitations. And there are so many examples. For example, amendment of the Constitution by Parliament. So there's a process for the amendment of the Constitution under Article 289, right, to 291 or so. So the amendment of entrenched provisions, Article 290, the amendment of non-entrenched provisions, Article 291, right? So you can have a look at the case of Professor Asari and Attorney General. This is known as the Constitutional Review Commission case. Professor Asari and the Attorney General, the Constitutional Review Commission case. So what basically happened in this particular case was that Asari brought an action, right, claiming that the president, Atamios of late memory at the time, he basically constituted a a committee of inquiry to investigate and give recommendations and make recommendations on the amendment of the 1992 Constitution, right? Professor Asari brought an action claiming that it is unconstitutional because it is only Parliament that can initiate the amendment of the Constitution. The court held that the fact that the Committee of Inquiry is going to make investigations and give recommendations doesn't necessarily mean that the president is amending the Constitution. No, these recommendations will be submitted to Parliament, and Parliament will have a working committee to review the recommendations, and then Parliament can start the process of amendment. Now, even in the amendment process, there are procedural limitations. For entrenched provisions, Parliament cannot amend by a strong majority or a two-thirds majority. No, for the entrenched clauses, we need a referendum. We need a referendum. I hope you got it. So it's very straightforward. So this means, right? This means that there are certain processes that are provided for under the Constitution, and you must abide by it. So for the procedural limitation, I give the passage of law under Article 106, the procedure for the appointment of judges under Article 144, the process for the appointment of ministers, Article 78, the procedure for the passage of subsidiary legislation, Article 11, Clause 7, the procedure for the amendment of the Constitution, Article 289 to 292, the procedure for the ratification of international laws, Article 27, Article 75, pardon me. So the procedure for the declaration of a state of emergency, Article 31. I hope you got it. Right. So there are a lot of procedures, or that those are procedural limitations that are provided for under the 1992 Constitution. And then we also come to the substantive limitations. So what are the substantive limitations? These are limitations in and of themselves. So they are not looking at the procedure, they are not looking at another institution. They are direct restrictions that completely forbid the organ for participating or doing a particular conduct, unless under certain exceptions. So number one, we have Article 3, Clause 1 of the 1992 Constitution that basically provides to the effect. Remember Article 3, Clause 1, right? It provides to the effect that Parliament cannot pass any law to make Ghana a one-party state. Yes, so this was dealt with the Re Akoto matter, right? That was way before the 1992 Constitution. Nkrumah had passed the law to amend the 1960 Constitution to make Ghana a one-party state under the CPP. Right now, using that particular authority to any action against the CPP, any conduct that was contrary to the authority of the CPP was declared wrong, was declared an offense. Right, Senior Nak, you have a question. You're on this race.
Hello, sir.
Yeah, Senior.
I want to understand before we came to what was the topic before you mentioned the constitutionalism. Are we looking at the choice of constitution or the principles under constitutionalism? I just want to be clear.
So I started with constitutional supremacy. I mentioned constitutional supremacy is the foundation, and then I started by looking at some of the theories or doctrines of constitutional law, and we started with constitutionalism.
Okay. Thank you.
Yes, welcome. Any other questions?
Nope.
All right, let's quickly move on. So I hope you got it. So now we are going to look at the substantive limitations. And I provided that a relevant substantive limitation is Article 3, Clause 1. So that's the Re Akoto case. So when, with respect to Re Akoto, right, Nkrumah arrested some persons, right, claiming that they're acting against the interest of the government because they were more or less working to breach the rule of the one-party state. They were working or cooperating to establish another party or work under another party, or they were expressing a different political ideology. So he was arresting them. Now he arrested them under the PDA. That is the Preventive Detention Act of 1957. And in that particular act, although you are entitled to human rights under the 1960 Constitution, the particular act allowed people to what? To more or less allow the president to arrest you indefinitely and imprison you indefinitely, and you are not even brought to trial, or there's no likelihood that you'll be brought to trial, or you can bring it to trial at any time. So in this particular case, they brought a petition claiming that this is a breach of their fundamental human rights under Article 13 of the 1960 Constitution. The court held, right? The court held that what it was constitutional, because what Nkrumah did was constitutional. Nkrumah was not because of the fact that it was just a mere ceremonial oath. I hope you got it. Nkrumah was not bound because of the fact that it was a ceremonial oath. So the human rights provisions were a ceremonial oath and they were not binding on the president at the time. I hope you got it. Right. So let's move on. Now, another form of substantive limitation is provided for under Article 107. It states that Parliament shall have no power to pass any law, A, to alter the decision or judgment of any court as between the parties, subject to that decision or judgment. So, Parliament cannot pass any law to alter the decision or judgment of any court. Right. This was dealt with in the previous in a previous constitutional matter, that is the Ladan case. So Nkrumah had ordered Ladan to be deported, but Ladan brought an action to the court claiming that he was a Ghanaian citizen, so he could not be deported for no reason. The court adjourned the case to receive evidence, but Nkrumah intentionally ordered National Assembly to pass a law called the Deportation of Ladan Act, which stated that any court proceedings right concerning Ladan must be cancelled immediately and he should be deported. I hope you got it. Right. So that's the relevant point in there. So more or less, he passed the law, right? He passed the law, that is the Deportation of Ladan Act, to interfere with the judicial proceedings at the time, right? So we are dealing with Article 107 of the 1992 Constitution. And Article 107 also states that Parliament cannot pass a retrospective law unless it comes under certain exceptions. So you can have a look at the Fatal and Minister of Interior and also the Shalaby and Attorney General case. So we have the case of Fatal against the Minister of Interior or Interior, however they say it. And then we also have the case of Shalaby versus Attorney General. Right. So we are done with constitutionalism. Let me give you the structure for constitutionalism. So it could be in this part, it could be an essay question, it could be a problem question. Now, when you are dealing with constitutionalism, you have to first of all start from the understanding or the principle of Article 1+1, that the Constitution is an expression of the sovereignty of the people. So, in the name of the people and for the welfare of the people, the Constitution will lay down the limits and the manner by which the arms of government must act. So, Article 1+1 is the locus classicus provision, or the main provision for what? The foundational provision for constitutionalism. So, under Article 1+1, the arms of government must act within the limits and the manner that have been provided for in the Constitution. So, what are the limits? What are the limitations? There are three kinds of limitations. We have institutional limitations, we have substantive limitations, we have procedural limitations. So I'm going to give you 5 major institutional limitations. Any of them are likely to come. So for if they're asking a question on constitutionalism, they will not bring an unknown limitation. They'll bring a limitation that is quite known. For example, the appointment of ministers, Article 78 of the 1992 Constitution, the case of J.H. Spencer and Attorney General, the removal the appointment of the Chief Justice and Judges, Article 144 of the 1992 Constitution, the case of Ghana Bar Association and Attorney General, Ghana Bar Association and Amegacha versus the Attorney General. So those are relevant cases. You can also look at Open Attorney General for the appointment of the Chief Justice. Also, what about the passage of laws, right? Institutional limitation, the National House of Chiefs, Wari and Ofori Atta and Article 106+3 of the 1992 Constitution. And there's also another institution that restricts Parliament in their passage of laws. That is the President under Article 106, clause 9 or 2. We'll find that later on, but it's under Article 106, the attempt of the President. Now, this was provided in 2 cases, Amanda Odoy and Attorney General, and also Richard Sky and Attorney General. Also, remember, there is also the passage of international laws, Article 75 of the 1992 Constitution, right? Ratification by Parliament. So that's the case of Margaret Bamford and the Attorney General. So you see, there are a lot of institutional limitations, right? You can have a look at the case of Professor Astari and Attorney General dealing with more or less the amendments of the Constitution. When you're looking at the amendments of the Constitution, Parliament will still have to assent to the President will still have to assent to the law passed by Parliament for the amendment of the Constitution. So you see, presidential assent, parliamentary vetting and approval. They are all relevant provisions in there. I hope you got it. Right. Also, you can look at the role of the Council of State, but I'll come to that when I'm treating the Council of State. Now, there's another important form of limitation. As I said, that limitation is known as the procedural limitation. This is providing the manner or the process by which the arm of government should act. So it's the same thing in the appointment of the MPs, right? That is the appointment of the ministers. You look at Article 78, there's a procedure. In the passage of laws, Article 106, there's a procedure. So look at the case for Article 78, J.H. Spencer, Attorney General. Article 106, you can look at Iswami Manan and Attorney General. You can also look at the case of Justice Abdullah and Attorney General. And Article 106, look at the procedure to provided for in the cases of Amanda Odoy and Attorney General, and also Richard Sky and Attorney General. Also pay attention to the case of Professor J. Itra and Attorney General. Right, where the law passed by Parliament is inconsistent with the Constitution, it will be struck out as null and void. Then you move on to also the substantive limitations. The substantive limitations are limitations in and of themselves. We are going to have three important cases or three important examples. Number one, Article 3+1. Parliament cannot pass any law making Ghana a one-party state. It is an outright prohibition of that particular act. So you are going to have a look at the case of Wiakutu, right? Wiakutu and 7 others. So that's in the matter of Wiakutu and 7, in the matter of Akutu and 7 others, right? And I've already explained that particular case. And for substantive limitation, you also have a look at Article 107 of the 1992 Constitution. So with reference to Article 107 of the 1992 Constitution of Ghana, we are going to have a look at the cases of Latan and Attorney General that deals with the fact that, in currently under our 1992 Constitution, you cannot, pass a law to interfere with the decision of the judge as between parties. So you can pass a future statute that can change the previous position of the law, but as between the parties, you cannot pass a law that interfere with the decision of a judge. And then also you cannot pass a retrospective law. Look at the case of Fatal and Minister of Interior. Look at the case of Shalabi and the Attorney General. I hope you got it. So you cannot pass a retrospective law, right? So it's very, very, very straightforward. Very, very, very straightforward. I hope you got it. So we are done with constitutionalism. So these are the major authorities to use under the doctrine of constitutionalism. Let's quickly move on to another important doctrine. So you are coming to separation of powers. Separation of powers is quite related to constitutionalism because it deals with also the classical separation of powers and the contemporary separation of powers. So you know that the classical separation of powers is where the arms of government are completely separate in their powers and in their functions, as well as their personnel. And then the contemporary separation of powers is where they are partially separate. So this is the modern form of separation of powers, that the arms of government are partially separate in the performance of their functions, and that there is a form of interdependence and checks and balances on these particular arms of government. So now let's start with the concept of separation of powers. Now, as I said, you have to understand the meaning or the definition. Then what was the authority or the reason for that particular concept? And then also we are going to look at how the 1992 Constitution expresses that concept, and then we are going to look at the relevant case law. So what is the concept of separation of powers? As I said, every arm of government, like the executive, the legislature, the judiciary, is made up of three things: the function of the arm of government, the authority or the power of the arm of government, and also the personnel of the arm of government. So for example, if you look at Article 57, that is the executive, right? The function of the executive is under Article 58 to enforce the law. But then the authority of the executive is vested in the president. That is the authority to execute the laws. And then we also have what is known as the personnel. That is the president and also the ministers, his delegates, and Article 58 and Article 78 of the 1992 Constitution. If you look at Parliament and Article 93, Article 94 of the Constitution, you realize that the membership of Parliament is dealt with dealing with the Speaker of Parliament, and also we are looking at the MPs. Those are the members of Parliament. Right. What is the function of Parliament? The core function of Parliament is to pass laws under Article 93 of the Constitution and Article 106 of the Constitution and Article 11(7) of the Constitution. That is the function of Parliament, to pass laws, and also Article 75 of the Constitution. We will come to Parliament later on, but I've mentioned and I've explained all those relevant provisions, so you get the idea of what I'm saying. Now, in reference to the the points of parliament, right? Their personnel, their authority, and also their function. So the function is to pass law. The authority is also, the authority that is vested in parliament, and certain immunities and privileges vested in parliament. If it's the judiciary, look at Article 125 of the Attorney General. There are personal judges, right? You can look at the superior courts and the inferior courts and all that. So you realize then that the Constitution makes provision for the arms of government. I hope you got it. Right. The Constitution makes provision for the arms of government, their functions and powers. But there is also what is known as classical separation of powers. Right. This provides that the arms of government should be separate in the performance of their functions and powers. You can look at John Locke, you can look at Montesquieu. So John Locke advocated for the separation of power to make laws from the power to enforce the laws. So he was saying that the monarch that has the power to enforce the law should be separated from the legislature or the representative of the common folks. That's the House of Commons, right? So that's the legislature. But then Montesquieu also gave something similar. He said the term separation of powers was coined by Montesquieu, actually. Separation of powers is a model that divides the government into separate branches, each of which has separate and independent powers. So he called for a complete separation of the arms of government. He called for a complete separation from the arms of government. So, what are the advantages of the classical separation of powers? The complete separation of powers. You have to have a fair idea of these. So, for the classical separation of powers, you are looking at the fact that where power is dispersed among, pardon me, so we are looking at efficiency and effectiveness due to specialization efficiency and effectiveness due to specialization. So when there is the complete or the strict separation of powers, right, or the classical separation of powers, it is actually going to lead to efficiency because every arm of government will focus on what they want to do or what is their mandate. So the executive will focus on implementing the laws, parliament will focus on passing the laws, and judiciary, I hope you got it. Judiciary be focused on interpreting the laws. I hope you got it. Interpreting the laws. So that is just a very straightforward point in there. Or passing judgment on certain matters. I hope you got it. Right. So now let's have a look at another relevant point in there. So where the power is dispersed among the various organs, it serves the core function of separation of powers, that there will not be any monopoly of power in the same authority. I hope you got it. So then that's the formal separation of powers. Right. Then we have the informal or flexible separation of powers. So this is where we are looking at checks and balances, cooperation, interdependence. What is the foundation and what is the advantages? What are the advantages of the informal separation of powers? You know, one of the major disadvantage of the formal is an advantage for the informal. So with the formal or the classical separation of powers, what occurs or what the problem is that the arms of government are not cooperating. So government is still acting for the welfare of the people, and so they must move in a particular direction in the public interest, and they must act uniformly, right, for achieving the same public purpose. However, if every arm of government is focused on what they are strictly supposed to do, there is no cooperation or interdependence. So, with respect to the fact that there's no cooperation or interdependence, what then happens is that the government will break down. I hope you got it. So, the major issue or the major problem that the contemporary separation of powers came to solve is that they called for the arms of government to work together. They called for the arms of government to work together. So in that sense, the executive will work together with the legislature will work together with the judiciary will work together with the executive. So all the arms of government will start cooperating. That means that their personnel will start cooperating. For example, the Attorney General Department is under what? The Ministry of Justice. The Attorney General is appointed by the President. But what does the Attorney General do? Is in charge for the initiation of all criminal suits on behalf of the government, all civil suits on behalf of the government. Right. So if there's a civil suit concerning the government of Ghana, you can sue the Attorney General. He represents the state. He has what? He has an audience in all the courts. So the Attorney General and the state prosecutors, they are working with the judiciary. Are you getting the point? What about the president? The president appoints ministers to aid him. But under Article 78, most of the ministers must be appointed from what? The judicial and the parliament. Right? So most ministers are MPs. Why? Because we need a certain sort of cooperation and interdependence. I hope you got it. So we are depending on each other. So the personnel that work in the executive, some of them are in the majority of them, that is the ministers, are also in the legislature. Right? In the parliament, when parliaments are passing law, they need assent of the president, because the president is the one who is going to execute the law. So he will know what critical problems are in the law. So when he's about to execute the law, you know how to handle it. So when parliament assents to a particular law, they must submit it to the president. So you will go through, you have a detailed review of the law. Then if it's okay with the provisions of the law, he can accept it. If it's not okay with the provisions of the law, he can also what? Reject it. I hope you got it. So if it's okay with the provisions of the law, he can accept it. If it's not okay with the provisions of the law, he can also what? Reject it. So, and then, or you can refer to the Council of State. Then if you reject it and Parliament votes on it by 2/3 majority, it will be binding on the President. Remember that under Article 106. So it means that there's a form of interdependence. So the judiciary is independent under Article 125 and Article 127. But who appoints the head of the judiciary? The Chief Justice. Pardon me, who appoints the Chief Justice, the head of the judiciary? The President. Are you getting the point? And Article 144 of the 1992 Constitution. So they are the same relevant provisions. So constitutionalism, the limitations, the institutional limitations, they fall under separation of powers, because one institution is checking the other institution. So you need to have an idea of at least 10 institutional limitations. 10. Because it can come under any of these. So let's give examples of the 10 institutional limitations or 10 forms of separation of powers. So number one, right, there is number one, and one of the major forms of separation of powers. So let's start with, let's use cases. So number one is the appointment of ministers, Article 78, G.H. Mensah and Attorney General. Number two, the appointment of judges, Article 144, the case of what? Ghana Bar Association and Attorney General, Justice Aban case. Number three, the removal of judges, Article 144 and 146, the case of Honorable Justice Tokonu and the Attorney General. Also, the case of Honorable Justice Derry and the Attorney General. I hope you got it. Right. And the case of A.J. Chum and Attorney General and Akwete also. And then we also have number four, the passage of laws, Article 106. The form of interdependence that comes in under Article 106 are sent to the President, Amanda Odoi and the Attorney General, Richard Sky and Attorney General. Right. So that is a form of what? Working together, interdependence, cooperation. Also, there is cooperation in the passage of international law, Article 75. That is the case of Margaret Bamford and Attorney General. I hope you got it. So there are a lot of cooperations in there. So I talked about the appointment of ministers. You see my favorites, the appointment of ministers, the removal of judges, the appointment of judges. Also, we also have the passage of international laws, right? We also have the passage of laws. So I've done the first five. So the passage of statutes, you need the assent of the president. The amendment of the constitution, you also need the assent of the president. So parliament will pass a law to amend the constitution. If it's by referendum too, in the end, they'll still need to pass it by an act of parliament. But then they need the cooperation of the president, the assent of the president. Have a look at the case of Professor Asari and the Attorney General. This is the Constitutional Review Commission case. Professor Asari and the Attorney General, the Constitutional Review Commission case. So you can have a look at that. It's also so important. Now, another important case is under Article 60/11, where the president and vice are out of the country, but there's interdependence. So they depend on the Speaker of Parliament. The Speaker of Parliament under Article 57 is the third person in precedent or the third person in priority in this country, pardon me. So he's the third most important person. So he's the president, the vice president, and the speaker. So when the president and vice president are out of the country, even if they are performing their ceremonial functions or presidential functions or executive functions, they need to depend on the speaker to sit in the authority or to hold the seat of the presidency or the executive till they return. One of them returns at least. So in this particular case, right, of Article 60 Clause 11, there's a form of interdependence. So that is the 7th point I've given. You can look at the case of Professor Asari and the Attorney General. So also the law says that the arms of government are separate. So a good example of the separation of the arms of government is that the president has immunity under Article 57 of the 1992 Constitution because of the concept of separation of powers. Very important. So although we have a lot of interdependence and checks and balance, the president is completely immune from the judicial review by the legislature. You cannot bring any civil action against the president of Ghana. You cannot bring any criminal action against the president of Ghana until within 3 years after he has left office. Have a look at Article 57, I think clause 4 to clause 6 or so. So when the president has left office, then your action must be brought within 3 years after he left office. So you can have a look at the case of MPP and Rawlings. We can also have a look at the case of Kufuor, Amidu and President Kufuor. I hope you got it. So 2 important cases, or Bilson and Rawlings, a 3rd case. So in all of these cases, you realize that they sued President Rawlings or they sued President Kufuor. The general principle is that you cannot sue a president. A president cannot be personally made a party to a suit. But who do you sue? It is not prejudice. It's not prejudice against Article 2, Clause 1. So you sue who? The Attorney General under Article 88 of the 1992 Constitution. Meanwhile, the Attorney General is an executive, right? But then he would represent the state in the judiciary, interdependence, checks and balance. So down the Attorney General represents the state. You represent if it's any act done by the president in breach of the Constitution, you can bring the action against him under Article 2, Clause 1. Just that the president cannot be personally sued or personally made liable for his actions as the president. Simple. Right. So then the case in point, as I've already given, MPP and Rawlings, Bilton and Rawlings, and Otto Kufuor, Amidu and Kufuor. So you can have a look at those particular cases. Let's quickly move on to the next one. The next one is dealing with the immunity of the speaker and the MPs. Right. You can have a look at Article 115, 116, 117, 118, 119. You can have a look at those provisions. They talk about the immunities and the special privileges of the members of parliament. In fact, whatever members of parliament do internally, it cannot be questioned by the court. It was explained in the case of Kufuor and Attorney General. Remember that the Speaker of Parliament was sued by Mr. Kufuor when he claimed that the purported vetting and disapproval of Justice Apalu was unconstitutional. So what did the Speaker do? The Speaker was struck out. So what happened was that the court struck out the Speaker as a party to the suit. Because even if you are challenging the act done by Parliament, you should sue the Attorney General. That's why most constitutional law cases deal with suits against the Attorney General, because the Attorney General represents the arms of government. So it's probably a suit against the arms of government. Do you get it? It's very, very straightforward. I hope you got it. Right. So you can have a look at the case of Kufuor and Attorney General. It was reinforced in the case of, I think the second case is the case of J.H. Mensah and Attorney General. And then there's another case in point. That is the 3rd case of Honorable Afenyo-Makin and Attorney General and Speaker of Parliament. Honorable Afenyo-Makin and Attorney General and Speaker of Parliament.
Daniel,
right.
can you mute, please?
In those particular cases, Daniel also please mute. In those particular cases, the court held that the Speaker of Parliament cannot be made a party to the suit. So the Speaker should be struck out as a party to the suit. It's very simple. Why? Because we need to protect separation of powers. That the President and the Speaker are immune from suit for whatever they do in the performance of their functions. It's very straightforward. So we are going to have a look at the other case, that is a member of parliament, Sam Okujeto Ablakwa against Reverend Kusi Bratton, this particular case. So Reverend Kusi Bratton, they wanted to serve some processes on Sam Okujeto, but the point was that they served him either on his way to parliament or his way from parliament. The court held that it's unconstitutional because they have separation of powers, and a parliamentarian cannot be served judicial proceedings on his way to parliament or his way out of parliament. So a parliamentarian cannot be served judicial proceedings on his way to parliament or his way out of parliament. That is the straightforward point in there. I hope you got it right. So you see, there are a lot of points, there are a lot of cases, but I'm giving you 10. So look at the 10 fundamental principles I'm giving you under separation of powers. So let's say number one, the president is, because of separation of powers, the president is immune from suits, civil and criminal suits, Article 57. Because of separation of powers, the parliamentarians and the speaker are immune from suits, right? Unless under certain special exceptions. I hope you got it. Right, that's also under Article 115 and ongoing. So in that case, you can use MPP and Rawlings, Kufuor and Rawlings, pardon me, Kufuor and Amidu and Kufuor, and also Bilson and Rawlings for the president. For parliamentarians and the Speaker of Parliament, you can use the case of Tufo and Attorney General, Honorable Afenuma Markin and Attorney General, and the case of G.H. Mensah and Attorney General. Right, so I've done the first two. So the first one deals with the president, the second one deals with the Speaker. I hope you got it, and the MPs. The third one deals with the passage of law, Article 106. You can use what? Presidential assent, Amanda Odoi, Richard Sky. Right? The fourth one is the amendment of the Constitution, Article 289 to 292. You can use the case of Professor Sarin, Attorney General. The fifth one is when the president and vice are out of the country, they are replaced by the Speaker, Article 60, Clause 11 of the 1992 Constitution. You can also use Professor Sarin and Attorney General, but the first one was the Constitutional Review Committee case, and this one I'm talking about is the case under Article 60, Clause 11. That's the swearing-in case. Right. Now, also another point of separation of powers is that there is interdependence in the appointment of the ministers, Article 78, G.H. Mensah and Attorney General. Interdependent, that is, you need vetting approval. So interdependent on also the appointment of judges, Article 144, Ghana Bar Association and Attorney General to find Attorney General. Right? Ghana Bar Association and then Amegacha and Attorney General. Then there is also what? Interdependence, right? And even the removal of the president under Article 69, even the passage of international law, you can look at Margaret Bamford and the Attorney General, and that's under Article 75. So there are a lot of cases, there are a lot of principles. So these deal with what is known as separation of powers. So the purpose of separation of powers, right, is already provided for under Article 1 Clause 1 of the Constitution, that the sovereignty of the Constitution resides in the people of Ghana, in whose name and for whose welfare the Constitution acts to ensure that the arms of government are acting within the limits and manner right provided for in the Constitution. Simple. So we are done with separation of powers. So the separation of powers is to protect the well-being of the people. I hope you got it. Separation of powers is to protect the well-being of the people. It's to protect the rights of the people. Because where powers are vested in the hands of one person, there is what? There is a likelihood of abuse, right? Power corrupts and absolute power corrupts absolutely. You know that saying. So that is it for separation of powers. Thank you. Do you have any questions? Let's quickly move on.
Council,
Yeah.
the issue of the government budget prepared by more or less the executive and approved by Parliament, could it also be an instance of separation?
Yes, there are a lot of examples. Yes. So it can also be an instance of separation of powers. As long as, because Ghana applies what? Contemporary or classical separation of powers. You get it? Ghana applies contemporary or classical separation of powers. So with contemporary or classical separation of powers, where two or more arms of government are acting together to achieve a particular purpose, the court will hold that the matter is contemporary. Because separation of powers. So two or more institutions, they are acting together. Do you get it? They are acting together. So they are doing what is known as interdependence and cooperation.
Hello, Laura.
Yeah, senior.
So please, can you use constitutionalism, the element there to answer separation of powers?
Yes. Yes.
Okay.
So constitutionalism, if you are looking at institutional limitations, all the examples of institutional limitations, right? I gave over 10 examples. All the examples of institutional limitations are a form of one organ checking up on the other organ. So this is also known as checks and balances. One more question and we move on. Any other question?
Yes, please, senior.
Yes.
I just want to clarify quickly on the Amanda Odoi case. I remember you
Okay.
saying something about the separation. I think my connection went off a bit, so just a little bit of clarification about the part where the Speaker of Parliament is also immune in a sense from a suit being brought against him. If you can just go over that quickly for me. Thank you so
Okay,
much.
so that wasn't within the Amanda Odoi case. That was in Honorable Afenyo Makin case. And you can also find it in the J.H. Mensah Attorney General. You know, although the court has the authority of judicial review, the court cannot interfere with the internal affairs of Parliament. So that means that you cannot sue the Speaker for performing his functions and operating internally within Parliament. You get it? So anytime they sue the Speaker, the court will not be concerned with the speaker being a party to the suit. You get it? Right. Now, this was basically applied from all the way back in the landmark case of Supreme Attorney General. In the Amanda Odoi case, I think the action was also against the speaker, but obviously she had to sue the Attorney General because under Article 88 of the Constitution, the Attorney General is the representative of Parliament. Yes, is a representative of the state, so he represents Parliament. Now, all these examples I'm giving, truth be told, I'm not relying on written materials. It's something that should be part of you. You get it? And most of my students know that sometimes I could, especially when I'm teaching on site, I could be in front of the board. You don't need materials for this. These are foundational principles. Article 1 clause 2, Article 2 clause 1, Article 57, 93, 125. Right? I'll go through all the relevant provisions. But the point that I'm saying is that there are some provisions that you must know of, and they must be foundational. That's why I gave you the 10. So if you didn't write the 10, you can go and listen to the recordings again. You can check out the 10 examples of constitutionalism and also the 10 examples of separation of powers. I gave 10 for those two topics, and I gave over 10 cases for each.
Hello, Senior.
Yeah.
Please, I think that maybe when we are done, then you can take the questions, please.
Yeah. So all right, that's okay. So let's quickly move on.
Last one.
Let's quickly move on. The time element.
Let's allow him to continue.
All right, so I'm moving on to the third topic. So you are going to have a look at rule of law. Right, you are going to have a look at the topic rule of law. So with reference to rule of law, right, it's also another important topic. So now, what is the relationship between constitutionalism, separation of powers, and rule of law? Constitutionalism, right, is talking about the limitations that are placed on the exercise of governmental powers. It doesn't necessarily need the constitution. So there can be constitutionalism without the constitution. As long as there's a limitation placed on the exercise of governmental powers, it is constitutionalism. Separation of powers means that the arms of government are separate in their performance, of their functions, in the exercise of their powers, and in their arms and in their personnel. But then in this particular case in Ghana, we practice what is known as contemporary separation of powers. So which means that the arms of government will work together. There's a form of interdependence and checks and balance. But they are also immune from interference, unnecessary interference from each other. So we've treated that. But rule of law is different. Rule of law is looking at the supremacy of the law, that the law prevails, right? And it comes under various doctrines or concepts. So let's have a look at our senior most proponent of rule of law. I hope you got it. Right. So let's have a look at A.V. Dicey. So according to A.V. Dicey, there are three tenets to rule of law. So the first tenet is that a person should not be punished unless for a breach of law. So that is rule of law. So rule of law is that the law prevails. So no person should be punished. So for example, no person should be punished in Ghana except for a distinct breach of the law. So you cannot be punished for anything unless it is a breach of the law. Or else the arms of government can take measures to be punishing individuals, although they've not breached the law. That is the first tenet. So the second tenet of rule of law is that everyone is equal before the law. Everyone is equal before the law. And the third tenet of rule of law is that the essence of rule of law is to protect human rights. So rule of law means that, number one, no person should be punished for something unless it's a distinct breach of the law. Number two, right, everyone is equal before the law. The law prevails above everyone. No one is above the law. You know that popular statement. And then number three, right? The purpose or the essence of rule of law is to protect human rights. So that is also under article, there are relevant articles. So let's start from the equality before the law, Article 17 of the 1992 Constitution. So go and read Article 17. It deals with the equality before the law. Everyone is equal before the law, and no person should be discriminated against in reference to their religion. Have a look at the case of Taron, Maguire, and Attorney General. You cannot be discriminated upon on the basis of your religion. Because the young boy came to school, he was having the dreadlocks because he practices the Rastafarian religion, Rastafarianism. And the court held that, yes, he's entitled to manifest his religion. So you cannot demand that he cut his hair. But that was a high court decision. You get it? Right. I don't think the matter has reached anywhere. But so far, there's a high court decision that respected the individual's right to freely express his religion under Article 17 and Article 21 of the 1992 Constitution. So everyone is equal before the law, and no one shall be discriminated upon on the basis of his religion. Everyone is equal before the law, and no one shall be discriminated upon on the basis of his or her sex. That is the case of Swatch against the Ghana National Fire Service. So in this particular case, right, dealing with equality before the law, they stated that when under their regulations, if a woman during practice gets pregnant, during their 1 year mandatory practice, if you get pregnant, a new fire service personnel, you get pregnant during 1 year, you'll be sacked. How can you sack a woman for getting pregnant? Because the men are enjoying that privilege. They can go and have sex and do not get pregnant, and they'll go and continue training. But if a woman has sex, right? If a woman has sex, she will get pregnant. It's likely, or you get the point. So in that particular case, you are discriminating because you are giving preferential treatment to the men, and you are giving a disadvantage or imposing a disadvantage against the women. You get it? Because most of them will be married, obviously. So in that sense, you are trying to indirectly infringe upon their free will. I hope you got it. So the court held that it was unconstitutional. And then there are other cases. So freedom of religion, freedom of freedom from discrimination based on religion, freedom from discrimination based on sex, freedom or gender, freedom from discrimination based on political opinion. Have a look at the case of NPP versus the Ghana Broadcasting Corporation. You can go and have a look at that case. So there are a lot of cases, but you know that although we are all equal before the law, right? As Yvonne Jennings said, some people are more equal than others. For example, the president and the MPs and the speaker, they are immune from certain actions. So, we treated that under Article 57 of the Constitution and under Article 115. And you can have a look at the case of MPP and Rawlings and the other subsequent cases I mentioned. So they are equal before the law, but then they are more equal than us. They enjoy special privileges. So they are positively discriminated upon for their benefit or their privilege. So this is positive discrimination. So the law allows for positive discrimination, that there can be a kind discrimination or privilege or benefit that is given to one party. For example, you can have a look at this act or this particular law, Affirmative Action Act, right? You can have a look at it. So they provide certain initiatives or measures or policies to support women, generally speaking, right? You can discriminate against foreigners. Look at Article 266 of the 1992 Constitution. So it's a lot. So although everyone is equal before the law, it's not everyone not everyone is at the same level of equality. So before the law, we are all equal, but there are different levels of equality. But we are all equal, but there are different levels of equality. Do you get it? So you can make a look at or go and reread those examples I've given. You are good to go. So let's move on to the next one. The next one he said was that no person should be punished except for a distinct breach of the law. Pay attention to Article 19 of the 1992 Constitution, fair trial. Article 19 clause 11 says that no person should be punished for any crime or any offense unless the crime is defined in written law and the punishment prescribed. That means that the crime has been written in statute and the punishment prescribed. Have a look at the case of Gla, an attorney general, right? He slept with his mother-in-law and his sister-in-law. He impregnated both of them, but he has not committed a crime, so he cannot be punished because sleeping with your mother-in-law and your sister-in-law is not incest. Although it seems to be wrong, it's not incest. So the law that was clearly defined was the law of incest, sleeping with your direct relative, like your daughter, like your son, like your mother, like your father, like your brother, like your sister, right, or your grandparents. So sleeping with a direct relation. But the court basically held that what? No, it doesn't work that way, right? Because he slept with his mother-in-law and sister-in-law, he has not committed an offense, and you cannot punish him because of rule of law. That the law should prevail. Everyone is equal before the law. No one should be discriminated upon, and no one should be punished unless the person has breached the law. No one should be punished because you feel like punishing the person. Gla in the Republic, Chachichukata in the Republic, Edmond Ado in the Republic. They are all in the material on the Google Drive. Go have a look at those important cases. Also, right to fair trial. There are about 8 cases, like Republic and Attorney Republic versus Eugene Balfour Puni, and a lot more, right? Important cases in there. Go and study it. Go and study it really well. Do you get it? So now we have a look at the third one that says that the essence of rule of law is to protect human rights. The essence of rule of law is to protect human rights. Now, for the purposes of the class, I'm going to give you the landmark authority for each and every human rights provision in the Constitution, apart from, some of the minor ones. So now we are just shifting a bit to human rights, because the essence of rule of law, equality before the law, and the application of the law, and the law being supreme, is to protect the human rights of the people. That's the essence of rule of law. So now pay attention to Article 5 of the Constitution. What I've learned is that over the years, when they are setting up a question, especially constitutional law, right, there can be a matter of breach of the provisions of the Constitution. And one of the major provisions or chapters in the Constitution is chapter 5. There are a lot of substance in there, or there's a lot of substance in there. So what are the relevant cases? So I'll just rattle through all of them because of the time element. But there's a whole lecture of human rights that has been recorded and uploaded onto the Google Drive, the Legis Drive. It's about a 3-hour lecture on human rights. So it has all the cases and the authorities, how to address human rights questions. There's a whole table. You get it? Now look at it. Article, let's say 12 is the general provision for human rights. Article 13 is the right to life. But our right to life can be restricted upon in the public interest and the respect of the rights of others. For example, high treason, Republic and Dr. Bakpam. You can have a look at State and Autry. You can also have a look at Dexter Johnson and the Republic. So they've all been explained in there. But the point is that although you are entitled to your right to life, the law, the court order can take away your right to life. They can also take away your right to life in self-defense, like Yebra in the Republic. So there are a lot of cases, and then there are a lot of breakdown of the principle in there. But because of the time elements, let's move on to Article 14, personal liberty. Dealing with unlawful arrest. I'm sure when we're having the third law class on unlawful arrest, there are a lot of references to the case of Asante and the Republic, and the fact that for there to be a lawful arrest, you must be told the reason for the arrest and the right to a lawyer of your choice. I can give you 4 cases under personal liberty, right? But there are a lot more. So, but some of the cases, you can use Asante and the Republic here, and Kobina, Martin Pebu cases and all that. But there are a lot more breakdowns on human rights under the personal liberty, right? Forced imprisonment, unlawful arrest. You get it? But then there are 5 bases upon which you can be reasonably arrested, or the arrest can be justified by the order of the court or under the authority of the court, right? If the person is a child and it is in the welfare of the child, if the person is insane, an infected person, if it's for the purpose of the extradition of the person, and also for the removal of the person or deportation of the person out of the country. And the 5th one being the commission of a criminal offense. So you can be arrested based on any of these provisions. So you see, the essence of rule of law is to protect human rights. Look at Article 15 of the 1992 Constitution, right to personal dignity. There's an important landmark case in there. You should just go and have a look at that. But more or less, when people were working for the EME, they were carrying the 9th soil on their heads, right? That's a Jian and Attorney General. So they're carrying the 9th soil on their heads and all that. And the court said that, no, that is a breach of dignity. Right, Article 16 doesn't really have a case. Article 17, you should check out the discrimination cases. We can have a look at the case of MNCMA and Attorney General, NPP and IGP, and the other cases I've mentioned. But for each particular form of or type or basis of discrimination, there is a landmark authority that you have to go and pay attention to. So the cases must be on your fingertips. The authorities must be on your fingertips. So I'll be able to know which case to apply. For example, if it is against your freedom or your right to protest, you have to use the case of NPP and IGP. That talked about the right to protest under Article 21 of the 1992 Constitution. Have you seen? So there are a lot of major landmark cases that you must use to carry on the point. If you are able to apply the landmark case, you are good to go. Right, and there's a structure that I've been teaching on multiple occasions and tutorials on how to, come to that particular conclusion. You don't just start from the landmark authority. Applying the rule of sources of law and the authority structure, you can be able to communicate to the examiner the breakdown of the authority all the way from the Article 1+1 to that particular subject matter provision. So there are a lot of ways to do it. But let's quickly look at other provisions like spousal rights. You get it. For spousal rights and Article 22, you can look at the case of AJ and AJ, right? You can look at the case of Mensa and Mensa. You can look at the case of a champion and a champion. So anyone, we treated spousal rights under immovable property. So that is the right to own property. So more or less under Article 18, you have the right to own property either alone or in association with others. Have a look at the case of AJ and AJ. So the principle in AJ and AJ has been explained in the material. So with respect to the matter dealing with constitutional law, right? With respect to the matter dealing with constitutional law, we can have a look at the fact that under spousal rights, there are different levels. We had the historical basis, then it went on to the principle of substantial contribution, equality is equity, and then also the current principle. So that was all broken down under the land law notes. I hope you got it right, because it deals with landlord. Compulsory acquisition, Article 20. Remember, I gave 5 important cases under compulsory acquisition, right? And I mentioned that you could use Samoku Jeto and Jekobechebi Lamte, and also you could use the Nipo Bitetechu case for both to explain the public interest. Public interest under Article 295 of the 1992 Constitution, Article 20, that the compulsory acquisition, because you are all equal before the law, everyone is entitled to own property, but the state can acquire the property in the public interest. So for compulsory acquisition under Article 20 of the 1992 Constitution, there are 5 things you have to note, and I explained them in the previous lecture. So first of all, it must be by law, it must be by the public interest, there must be reasonable justification for the acquisition of the particular property, and also there must be the arrangement for the prompt payment of fair and adequate compensation or granting alternative land. And the 5th one is also very important. It deals with the right of or the first option to re-enter or reacquire the premises by the previous owners. So that is it. But then there are lots of fundamental principles in there. You can have a look at Memuna Amudi and the other relevant cases that I dealt with yesterday and I provided on the Google Drive. So you could also set up special notes on, compulsory acquisition and all. So the next one, we have to Article 21 dealing with the fundamental freedoms, freedom of movement. I've given the case of freedom of movement. I've given the case of freedom, the right to protest. I've given the case of freedom from, freedom of religion. I hope you got the freedom of religion, freedom of expression. You can have a look at the Montier 3 case, where certain people came on the radio to insult and threaten judges. And then the Supreme Court summoned them. And they claimed they admitted to it. And the court held that although you have the freedom of expression, you have to make sure that it's done in accordance with the law and in the public interest. Right? In the public interest, there are certain comments that you cannot make. You cannot incite the public against judges. It amounts to contempt of the court. So that was the Montier 3 case. You get it. So it's very, very, very straightforward. So you see all these fundamentals. So there's a whole point of the notes under the concept of fundamental human rights. I hope you got it. Right. So you just pay attention to those provisions. So we move on, but we are still on the tenets of the rule of law. So there are 3 main important things you have to take note of. Number 1, everyone is equal before the law. Number 2, no person should be punished, right, except for a distinct breach of the law. And then number 3, right, and the third one is protection of human rights. The essence of rule of law is to protect human rights. So those are the 3 relevant points. And for each of the tenants, you are going to have a landmark authority. I hope you got it. For each of the tenants, you are going to have a landmark authority. So it's very straightforward. Right, so let's quickly move on to the next one. So we are done with rule of law, right? I've explained the points of positive discrimination. I've explained some fundamental human rights protection provisions under Chapter 5 of the 1992 Constitution. And I've also explained Article 19, Clause 11, that no one should be punished except for a distinct breach of the law. So you can look at the Chikata case, Edmond Addo case. Those are the relevant authorities, the locus classicus authorities on Article 19, Clause 11. I hope you got it. Right, so it's very, very straightforward. Now let's quickly move on. So the next topic after rule of law let me see. All right, so we are going to have a look at the topic of judicial review. Thank you, but just give me a moment. Let me just have a water break. So it just takes 30 seconds. All right, so I'm back. All right, so thank you for the break. So we are quickly moving on to the next point. So we are going to have a look at, as I said, judicial review. So what is judicial review? This is a very, very important, theory under constitutional law. Now, if there's a question on constitutional law, if there is, a problem question, right, where the matter will have to be sent to the court, there is an element of judicial review. Because judicial review is the authority that is granted to the court to review the actions or the omissions or the laws passed by the other organs or administrative bodies to ensure that they are consistent with the Constitution. Simple. I repeat, judicial review is the authority, right, that is vested in the court to review the actions of the arms of government, right, or administrative authorities to make sure that those actions, omissions, or laws are consistent with the provisions of the Constitution. So that is the element of judicial review. So you have to make sure that they are consistent with the Constitution. So it is the formal assessment of actions, omissions, or laws passed by organs of the state, administrative bodies, or state institutions, with the possibility of instituting change if necessary in the circumstance, that is a breach of law or the Constitution. So you cannot have a judicial review of a private contract between two private persons. No. You cannot have a judicial review of a matrimonial issue or a divorce case. No. Or a common tort action or trespass to land action. No. Judicial review is broadly divided into two. We have what is known as constitutional review. We have what is known as administrative review. Let me tell you how to structure it. So for constitutional review, we are looking at Article 1 of the 1992 Constitution. The sovereignty of Ghana is vested in the people of Ghana, in whose name and for whose welfare the arms of government are to act. So more or less, for the constitutional review, the right is vested in the Supreme Court to review the actions of the arms of government or the omissions of the arms of government or the laws or enactment of the arms of government, right, to determine the constitutionality. So that is provided for under Article 2, Clause 1. So the purpose of judicial review here, in this sense, constitutional review, is to fulfill the public interest purpose of ensuring that all the organs are acting consistently with the provisions of the Constitution. So that is the public interest purpose. Remember, under Article 295, public interest is anything that inures to the benefit of the public. That is public interest under Article 295. It must inure to the benefit of the public under Article 295. So Article 2 Clause 1 says that you can bring an action. Remember, I treated that any person here means any natural person who is a citizen of Ghana, or any artificial person which is also registered in Ghana. So an artificial person like a company, like a political party. So for a company, Attorney General and Balkan Energy, you can have a look at the Balkan Energy case. We also have a political party. You can have a look at NPP and NDC. You can have a look at the NDC and Electoral Commission case. You can have a look at NPP and IGP case, NPP and Attorney General case. I'll come to these cases later on. Now, the point I'm trying to say is that because it is in the public interest, the local standard for constitutional review is vested in the the Ghanaian citizen. The local standard for constitutional review is in the Ghanaian citizen. So any Ghanaian citizen can bring an action to the Supreme Court for constitutional review. That is to review the actions or the omissions or the laws of any organ or any public body to ensure that it is consistent with the Constitution. That is what is known as constitutional review. Very, very important. So all the cases I've mentioned, a lot of the cases I've mentioned, especially where it involves the state and the Attorney General is being sued, it is constitutional review. Because we want to determine whether or not an action is constitutional. Justice Abdullah and Attorney General, NPP and Attorney General, Tufo and Attorney General, Mensima, and I can give you 20 cases. Go and have a look at all of them. You get it. Mensima and Attorney General, Professor Epiaj Etu and Attorney General, Martin Pipo and Attorney General, Derek Edu Jimfi and Attorney General. So all the briefs have been uploaded. So more or less, it's very important to note, right? It's very important to note that with the concept with this particular concept, right, of judicial review, okay, constitutional review, the court will have the inherent right and authority to examine the action to determine its constitutionality, and it must be in the public interest. So it doesn't go to the High Court, it goes to the Supreme Court under Article 130 of the 1992 Constitution, where we are in the High Court or the Court of Appeal or any court, and there's a matter for constitutional interpretation that is raised, you must refer that matter to the Supreme Court under Article 130 Clause 2 of the 1992 Constitution for interpretation. So the court will store the case and they will refer the matter for constitutional interpretation or review to the Supreme Court, because the Supreme Court is vested with the authority for constitutional review. The High Court is vested with the authority for what is known as administrative review. Administrative review is where we are going to review the actions of administrative bodies and organs. I hope you got it. We are going to review the actions of administrative bodies or organs to determine their what? Constitutionality. I hope you got it. To determine their constitutionality. And in this particular, to determine whether or not they are acting with administrative fairness and are fulfilling what is known as the Rensby principle. I'll come to that. So you know that under Article 23 of the 1992 Constitution of Ghana, which deals with administrative justice, every administrative body in Ghana must act fairly and must act reasonably. And if you are personally aggrieved by the action of the administrative body, you can take the matter to the High Court under Article 33 of the Constitution, for judicial review in the form of administrative review. So if the High Court determines that the action of the administrative body was not fair or was not just, depending on the circumstances of the case, the High Court can issue or order any of these prerogative orders or rights. We have the number 1, the habeas corpus. Number 2, the certiorari. Number 3, the mandamus. Number 4, the prohibition. Number 5, the quo warranto. So these are the reliefs. So when an administrative body is acting inconsistently with your rights or being unfair against you, you can ask for certiorari to quash the decision or the order of the administrative body. That was the case of Awuni and Wayek and Abuaji and GCB. Now, if you look at the points of these cases, you realize that they deal with administrative bodies, government bodies, not private persons. We'll come to personal, rights later on. I'm sure you did it under Ghana legal system or whichever topic, right? We had a full review with, I think, the latest class on all the remedies that are available. And we treated a lot of remedies. So under remedies, right, you can have a look at what is known as the private remedies, right? We have the legal remedies and the equitable remedies. Okay, so the legal remedies, we have damages declaration, equitable remedies, legal remedies, we also have the prerogative rates. Equitable remedies, those ones under equity, like injunction, specific performance, and others. And there are fundamental cases for each remedy. So it has been provided in the material. So there are fundamental cases for each remedy. So when you're answering a question and they say advise the party, you must give an authority or you must give an advice, right? So in your list of authorities, you have to confirm to them which particular advice you are giving, which particular remedy they are looking out for. For example, if you are telling the party that he or she is entitled to settle Warai, what was the basis? Which particular case entitled you to refer that particular remedy? I hope you got it. Which case referred you to, and which case was the basis for you making reference to that particular remedy? So every remedy has a case law or authority that you are supposed to use, right, to justify the remedy. So the court doesn't just impose a remedy; they need to justify the remedy. So if you are looking at habeas corpus, mandamus, certiorari, quo warranto, right, and prohibition, there are cases for each of them to justify the remedy. And I'll come to some irrelevant points later. But the purpose of judicial review is that they're actually safeguarding the rights of the people to ensure, remember, everything under constitutional law is dealing with the sovereignty of the people. That's why I said always make reference to Article 1 Clause 1. It's dealing with the sovereignty of the people. So this means that under Article 1 Clause 1, the sovereignty of the people is vested in the Constitution. So the Constitution works for the benefit and the welfare of the people. So for judicial review, in the form of administrative review and constitutional review, we are looking to protect the welfare of the people. Constitutional review is to make sure that the laws and the actions and the omissions are not inconsistent with the Constitution, because it can lead to an abuse of power. Same with the administrative review, that the administrative organ is not acting so unfairly, right, that it can, breach the particular person's human rights. So the administrative body must be reasonable and must justify their actions. Look at Article 296 of the 1992 Constitution. The exercise of discretionary powers implies a duty to be fair and just. You get it under Article 296. And I explained that under Article 11 of the 1992 Constitution, the constitutional provisions are more important than the cases. Make sure you are well grounded in the relevant constitutional provision. Every constitutional provision that I've mentioned is important. Don't be saying under the Constitution. No, that is not how you answer constitutional law questions. You say administrative review under Article 23 of the Constitution. Constitutional review under Article 1 Clause 1, Article 1 Clause 2, Article 2 Clause 1, Article 130, and Article 30, Article 130 of the Constitution. That's it. You get it. And public interest, Article 295. That's the point. So you don't just guess under the Constitution, and you are getting the marks wrong. Unless obviously you don't know the exact provision, but you can be able to explain the provision. You might probably get a half mark. You get it. Very important. So let's quickly move on to the case law for the various types of reviews. So for constitutional review, the locus classicus case. It's a foreign case though, Marbury and Madison. Then we also have the Ghanaian position into foreign attorney general. So for constitutional review into foreign attorney general, the court reviewed the purported vetting and disapproval of Justice Apalu and stated that it was null and void because it didn't comply with the transitional provisions of the Constitution. For Marbury and Madison, he wanted the court to review the action of the executive, that's the Executive Secretary of State, and to order him by mandamus to grant him the seal or give him the seal of authority as a judge. The court held that, yes, although he's entitled to it, they cannot grant it because of the rule of remedies. That's why I was saying that under the concept of review, it's very important to understand that for every type of review, there are remedies. So mandamus could not be granted by the Supreme Court of the United States of America because they weren't the court that were entitled with jurisdiction or vested with jurisdiction for that particular point of action at the time. Very simple answer. And then there are other cases. So I've given 10 cases in reference to judicial review. Cases I've mentioned already. Number one, we can have a look at the case of Martin Pebu and Attorney General, right, the bill case, 48-hour case. So the court reviewed what was happening, the actions and omissions of the government, and stated that no, you have to be brought before the court within 48 hours because they enforced Article 12 of the 1992 Constitution. Non-bailable offences case. The court reviewed the Criminal Procedure Act 30 and held that you have to what? Cancel those non-bailable offences because now every person has the right to be granted bail irrespective of their offence. And Article 14. The court looked at the case of Derek Edu-Jemfi and Attorney General, and the court held that under the Companies Act, that particular directive for potential directors to write whether or not they've been charged with an offence was unconstitutional in breach of Article 14 and Article 19 of the 1992 Constitution, in breach of Article 19. Because the mere fact that you've been charged with a criminal offence doesn't mean that you are guilty of the offence. There hasn't been any fair trial yet that has held you guilty of the particular offence. So why do you need to disclose that you are charged? It doesn't make sense. And that was in the case of Derek Edu-Jemfi and Attorney General. In the case of Professor Epiaije Etua and Attorney General, the court made reference to the Imposition of Restrictions Act and stated that this Imposition of Restrictions Act is unconstitutional. So they reviewed it. That is a law passed by Parliament, and they declared it as unconstitutional. In the case of Iswami Manan and Attorney General, the court made reference to Article 106, the explanatory memorandum, and said in the Narcotics Control Act that was passed, Section 42 did not come with an explanatory memorandum, so it should be struck out. Now, you can only do judicial review of an act or omission or law, or that is an enactment. You cannot do judicial review of a bill of Parliament. That was explained in the case of Amanda Odoi against the Attorney General and Richard Sky against the Attorney General. The court held that a bill is still in the process of becoming law. It is not a law. It is not an enactment. So I cannot take a bill to say something is inconsistent with the bill or the bill is inconsistent with the Constitution. No, there can be no review of a bill because it is not a law yet. You get it? So that's Amanda Odoi and Attorney General in the case of Richard Sky and Attorney General. So these are prominent cases on constitutional review. MPP and Attorney General, constitutional review. The 31st December case, that the celebration of coup d'etat, that announcement to celebrate coup d'etat, that intent to celebrate coup d'etat with public funds, it was reviewed by the court, that is the Supreme Court of Ghana, a landmark case where the court stated that after reviewing the intention, the particular action, and the intent to celebrate coup d'etat with public funds, you are going to declare it as unconstitutional because it is in breach of the underlying meaning or the spirit of Article 3, Clause 4 of the 1992 Constitution. So it's in breach of Article 3, Clause 4 of the 1992 Constitution. So it's unconstitutional. I hope you got it. So you realize that for constitutional review, there are a lot of provisions that you can make reference to. And then you come to administrative review. So you just have a look at Awuni and Wayek, the ex parte Banaman, or say ex parte Abesi Awusu, Republican in Bafo Buni. I've given a lot of cases under administrative review. So you can also have a look at it there. Thank you. So we are done with judicial review. And as I said, every review is backed by remedies. So there are also judicial remedies. You have to understand the whole concept of judicial remedies, especially the fact that there are legal remedies and equitable remedies and the relevant case. So after reviewing, the court can apply a remedy or grant a remedy. I hope you got it. Right. So let's quickly move on to the next one. So we are going to have a look at the next topic, natural justice. We are going to have a look at natural justice. Natural justice, if you look at every point of the constitutional theory, you realize that they are all related. Constitutionalism is to limit the arms of government to ensure that the people are protected, the sovereignty and the rights of the people are protected. The rule of law is to ensure that the law rules or the law prevails so that the rights of the people are protected. Natural justice is for the same purpose, that you are providing what is conscionable, what is right, what is just, right? Natural justice. So there are certain important principles of natural justice, two important principles: the right to be heard and the right to fair, that is the right to be heard, that's the right to fair trial, and also the right to an impartial judge or court or panel, right? So that is the odi altering pattern and the nemo juris in casuasua. So when it comes to natural justice, we are looking at two important principles. Odi altering pattern, that is the right to be heard. And then we also have nemo judes in casual sua. That is the right to an impartial judge. So this basically means that there is a connection. It means that you cannot be a judge in your own cause or matter. So as a judge, you cannot have a pecuniary interest in the matter. You cannot be biased. You get it? You cannot have a personal interest or connection or relationship with the party to the suit or with the subject matter of the suit, because there is a strong likelihood of bias. So that is the point. Why? Because we want to protect the people. We don't want people facing courts or judges or particular public tribunals or disciplinary authorities that are biased against them. No, it will not be a fair trial. And also with the concept of fair trial, you have to give them the right to be heard. So the administrative right to be heard, right? It comes in a lot of forms. You have the right to be exposed to any information that will be used against you. You have the right to be given reasonable notice to defend yourself. So the right to be heard, the odi authorem partem rule, basically means that if you are charged with an offense or if you are charged with a wrongdoing, right, especially by a public authority or public body, official or court, right, that particular decision of the public authority, body, or official or court will be binding on you and might affect you personally. So in that particular case, before arriving at the decision, they must give you the right to be heard. They must summon you and give you a fair trial. They must hear your position on the matter. They must make available every evidence or information that they'll use against you. They must specifically state what your charge is or what the wrongdoing is. So yes, you are working for maybe the government and they wake up one day and they sack you. What is the basis for the sack? You don't just get up and sack someone or say the person has been suspected of stealing, so you sack someone. Ex parte Bannerman case, the committee of inquiry to investigate the State Fishing Corporation. They went there, they said they suspect Bannerman of stealing, they are removing him from office. How? No fair trial, nothing. No summons, no nothing to back their decision. You get it? So that is the right to be heard. Awuni and Waye, you know that case. I'm not going to it again. But it's a landmark case. Obviously, the court held that what the students deserve the right to be heard. So they struck out the decision of WAEC. Abaji and GCB, Ghana Commercial Bank, right? They sacked him. The court held that no, he's entitled to the right to be heard. If you are sacking him as a disciplinary action, what was the basis? What are the grounds for that particular disciplinary action? Now, the right to be heard also does not mean that you intentionally fail to make yourself available. Look at Article 19 of the 1992 Constitution, that you are entitled to a lawyer, you are entitled to, the evidence, to have receipt of the evidence, or to receive all the evidence that will be used against you, all the documents, all the information, etc. You are entitled to be given reasonable time to review the materials and the documents and the evidence so as to prepare your defense. But then if you decide not to appear, right, what will the court hold against you? They'll hold that you decided to waive your rights. I hope you got it. They'll hold that you decided to waive your rights. So it's very, very straightforward. So of course, although you are entitled to the right, though you can waive your right by intentionally refusing to abide by that particular right. So that was explained in the landmark case of Republic versus High Court, Cape Coast, ex parte John Bongisi. The facts are so interesting, but let's just state the holding. The court held by Duchess JSC, a person who disables himself or herself from being heard in any proceedings cannot later turn around and accuse the adjudicator of having breached the rules of natural justice. So what is the court saying? That if you intentionally made yourself unavailable for proceedings, you were notified of proceedings against you, you were told to submit yourself for proceedings, then you decided not to submit yourself for proceedings, then what will the court hold against you? That you are not entitled to rely on the right to be heard. I hope you got it. You are not entitled to rely on the right to be heard. So that is just the very straightforward points. Very, very, very
Please,
straightforward.
the Republic versus High Court.
Ex parte Bongisi.
Okay. All right. Thank you very
The
much.
C is SEY. Welcome, senior. I think there's a Google Drive link that has the material, so you can join the page or something, the latest page, because we'll be having a lot of subsequent sessions going through, questions and answers on constitutional law for the group members and all, especially before the exams. We'll be having long-term sessions. So make sure you are part of it.
I'm already there, boss.
All right.
Is that
So
what?
later
Council, is that what you have
break.
dropped?
There's no break. I have to continue, please. Let's finish up. So I was still on the right to be heard. So I gave cases and I referred to the Republic, Republic and High Court ex parte Bonjisi. I hope you got it. So that is it. Now let's have a look at the right to an impartial judge. Nemo judes in casu sua. So this is now dealing with the judge or the adjudicator, or the one who is going to make the decision affecting you. So you must not be a judge in your own cause or matter. You must not have a pecuniary or financial bias, relational bias, or predetermination of the matter bias. So that means that there are 3 types of general bias you can have. So this is a pecuniary. I hope you got it. So this is a pecuniary or financial bias, right? Relational bias or predetermination of the matter. So what this basically means is that more or less, if you're a judge, you should not have a relational bias. You shouldn't be so close to the parties in the suit that there is a reasonable foreseeability that you are likely to be biased. So in Ghana, we deal with what is known as the real likelihood of bias. So the mere fact that you're a friend of the person is not enough. The party who is claiming bias must be able to prove before the court that you, the judge or the adjudicator, or the one making the decision, you are so close to the other party that your relationship is going to affect your impartiality, and that you are actually going to have a personal interest in the matter. Pecuniary bias means that what you shouldn't have a financial interest in the matter or a property interest in the matter. I hope you got it. So it says the judge should not have any financial interest in the matter. The judge is not supposed to be paid by the parties or receive any bribes or commissions from the parties, right? So if you investigate the case, like the case of Dimes and Grand Junction, right? Dimes, DIMES, and Grand Junction. So in this particular case, the judge owns shares in the company, and the matter came to before him in court. The court said that he is very likely to be biased. So more or less, where there is an ordinary suspicion, usually backed by evidence that the judge has received or has a financial connection to the case should be transferred to another judge unless that is impossible by law. So that was the case of Dimes versus Grand Action. If I say versus, because I want you to know the difference. It's usually Dimes and Grand Action. Grand Junction, pardon me. It's a civil case. But usually I say versus, so you know where the V comes in. You get it? So Dimes versus Grand Junction, right? So relational interest, Ghana's perspective is a bit tighter. So it is not just a mere suspicion of bias in Ghana. It must be a real likelihood of bias. So there must be a real likelihood that you are going to be affected by whatever relational interest or whatever pecuniary interest you have. I hope you got it. And then also, it is reasonable to expect that you'll be biased. So, for example, if the Constitution, right, says that the matter will be settled by this particular person, then obviously the prosecution override that particular way of natural justice. So, one particular good example is the fact that under the matter of bias, the Constitution, right, can override it. You get it. Now let's have a look at cases for the general authorities. Attorney General in Sada. I've explained the full facts and briefs in the Google Drive, but the particular holding is that the court held that to disqualify a person from acting in a judicial capacity on the ground of relational bias, a real likelihood of bias must be shown. On the evidence, the mere suspicion of bias is not enough. On the evidence, the mere suspicion of bias is not enough. A real likelihood is a high probability that the judge is likely to be influenced by his connection. The court held that mere fact of friendship or the fact that the judge is connected indirectly to the person will not affect the case. Right. You can also have a look at the case of Republic against the High Court ex parte ABC Awusu. So Republic and High Court ex parte ABC Awusu. The court held that where a judge is having foreknowledge of the matter, or he has predetermined the matter, he has made his own opinion or conclusion on the matter, or he has a strong or direct influence or connection or relationship with one of the parties to the suit, right, or where the conduct of the judge is questionable. From his conduct, you can see that he has a private interest in the matter, and it is so strong that it is likely to influence his decision in the case, and he cannot be impartial. they'll simply have to transfer the matter. So that is the case of ex parte Apesi Awusu. So there are a lot of matters that deal with bias. Apart from relational bias or pecuniary bias, there's also the predetermination of the matter. So sometimes, as the trial is ongoing, you can see clearly that this judge has predetermined the matter. He has given his opinion. That's why judges are not supposed to express their opinion on court matters on TV. If you've noticed something, you've never seen a judge, an active judge, come on TV to express his opinion on a case, because they are under the rule of impartiality. So even if the matter was against the Honorable Chief Justice Tokonu, you not see one of the judges holding an interview. And I'm talking about the judge who's on the matter. I'm not talking about maybe a lawyer or a prominent or retired judge. No. I'm talking about the one who is on the matter. He cannot come and be holding court interviews or giving his own opinion. That means that he has already made up his mind. What are you going to persuade him on? You get it? Right. So you can check out the ex parte Apesi Awusu case. That's the locus classicus case. And then you also have a look at Akufo-Addo and Kwasi Indon or Aidan. Right? So in this particular case, the court held that yes, there are matters of bias that can be popped up or that can be seen, but sometimes the court will have to override the bias or accept the bias, or the constitution would have to impose that particular bias. For example, the constitution says that the constitution says that the chief justice is to empanel the bench, maybe the Supreme Court bench, right? Or the chief justice has audience in all the cases. So unless you suspend the chief justice, even if the matter is going to affect the chief justice will have what? The right to constitute the panel. I hope you got it. Right. So if the person is performing his statutory duty, then you cannot claim bias. So for example, if the person is part of the Council of State and the president has to consult the Council of State, and this person is part of the Council of State, but the matter indirectly will affect or have an effect on the Council of State, there's nothing you can do. The person is still part of the Council of State. So it's not that he's biased. The Constitution has stated that the Council of State should handle this matter. I hope you got it. Right. So any matter dealing with bias, as long as the court realizes that it is a statutory duty, then you are not biased, because even if you are biased or whatever, the Constitution has or the law has given you that particular duty. I hope you got it. Right. So it's very, very, very straightforward. So that's with respect to judicial review. I hope you got it. Right. And pardon me, natural justice, right? So the natural justice is divided into two. The first one is order, altering pattern. That's what you must remember. I mean, the two. You must remember the two. So this is what you must remember, that natural justice is divided into two: order, altering pattern, and nemo juris in causa sua. But you have to understand the purpose of natural justice, that there must be fairness in the adjudication of disputes or the handling of matters in which a party or a person will be affected by the decision or order of the adjudicator or the person involved in making the decision. So where you know that your decision is going to affect someone, and I'm talking about public bodies, not your mother or your father's decision or your uncle's decision or your teacher's decision. No, that you are going to report your teacher to the court because your teacher was biased. No, that is different. You are talking about administrative bodies. We are talking about judicial bodies. We are talking about disciplinary authorities, where they are going to give decisions that are going to affect you, that are going to deprive you of your interests, affect your rights, maybe sack you from the institution or the public body, right? Like for example, the chief justice, you have to give the person the right to be heard, because you have to exercise the conscionable rules of natural justice. So fairness and what reasonableness. I hope you got it. Right. Now, you basically have to explain that for all the other pattern, we are focusing on Article 19 of the Constitution. And for the right to bias, right to an impartial judge, we are also having a look at other relevant provisions of the Constitution. I hope you got it right. The fact that, precedent, pardon me. So you can have a look at the case of Attorney General and Salah, and then also other cases like Dimes and Grand Junction, and also the case of Akufo-Addo and Kwasi Aidan, right? So we are done with bias. So we are done with constitutionalism, rule of law, separation of powers, natural justice, judicial review, and also constitutional supremacy. So now you are going to look at the constitutional effect of coup and revolutions, the constitutional effect of coup d'etat and revolutions. Right. Just a moment. All right, so let's quickly move on. I want to finish in before 10 o'clock, right? So it doesn't take too long. So let's have a look at the constitutional effect of coup d'etat and revolutions, right? So what happens in Ghana when there's a coup? Now there are two fundamental, or there are two, opposing theories or concepts. We have the theory of discontinuity, and then we have the theory of continuity. So you know that the theory of discontinuity was propounded by Kelsen. The theory of continuity was propounded by Finnis. So Kelsen, in his book, right, The Pure Theory of Law, propounded the theory of discontinuity. He referred to the Constitution as the basic norm. And he said there's something known as the basic constitution or the good norm. And this is the good norm, that every other law derives its legal validity from the good norm. So you can have a look at it like as an inverted pyramid. So it has a straight top and then it narrows down to the bottom. So the straight top or the platform that is at the top is the constitution, the basic norm. And every other norm derives its authority from the constitution. So every other norm relates to the constitution, that is the basic norm. So when there's a coup d'etat, right, it is only effective where the coup d'etat acts against the basic norm, or there's a new law or proclamation that is against the basic norm. And this is subsequently accepted by the people. So that means that for the Kelsenite theory, a coup can destroy the legal order and create a new constitution, or only if the proclamation, that is the coup d'etat law, right, has been accepted by the people as the new good norm, that is the new basic constitution. What it means is that the previous legal order will collapse and everything must be conducted under the new legal order. So, for example, if there's a coup d'etat in Ghana, right, according to the Kelsenite theory, the constitution will be abolished. And then, if the people accept the proclamation as the new law, then what this basically means is that the proclamation will be what? The new good norm. And every law must conform to the proclamation. So, if there is a conflict between the proclamation and the law, the proclamation will override that particular law. That's as simple as that. Simple. You don't need to explain any further point. Just go straight to the point. Say that under the theory of discontinuity, when there's a coup d'etat, and a coup d'etat comes by proclamation, a declaration that the good norm, that is the constitution or the basic law, has been overthrown. The government has been overthrown. So the government is acting based on a constitution or a good norm. So you've overthrown the government. You've passed your own proclamation, like the PNDC proclamation by Rawlings. You get it? Like the NLC proclamation or the NLC proclamation. So when there's a coup, they pass a proclamation. So if the proclamation has been accepted by the people, then it leads to a what? A new legal order. So the old legal order will completely collapse and then there is a new legal order. It's very straightforward. So that's the point of Kelsen, the Kelsenite theory of discontinuity. Now, the Cousinite theory of discontinuity does not apply in Ghana. In fact, when the argument was made in the case of Salah and Attorney General, the court held that it is a foreign concept. In Ghana, we don't apply the theory of discontinuity, but we apply our own contemporary form of continuity. Now, look at the 1992 Constitution of Ghana. Under Article 3, Clause 4 of the 1992 Constitution. First of all, Article 3, Clause 3 says that a coup, that is treason, is a criminal act. So you are liable to suffer death. So any person who attempts to abrogate the 1992 Constitution, that is commit a coup. Any person who attempts to commit a coup, any person who attempts to more or less, destroy the Constitution has committed a wrong. And in reference to that, the person will be what? Liable. I hope you got to be reference to that. The person will be liable to suffer death I hope you got it. With reference to that, the person will be liable to suffer death. So that is the point in there. Now, it means that under Article 3, Clause 4, there is a duty that is imposed on every Ghanaian to defend the Constitution. Do you remember? So there's a duty imposed on every Ghanaian to defend the Constitution and to restore the Constitution to its particular legal order. So even though there is a coup d'etat or treason and the Constitution has been abrogated, we are all under a duty to restore the Constitution to this particular order. That means that we don't apply theory of discontinuity, that when the proclamation or the coup d'etat is accepted, we are under a new legal order. I'm talking specifically of the applicable law, that is the 1992 Constitution. This was also explained in the case of Ekwam and Pienim, or Ekwam versus Pienim. So in this particular case, he was claiming that he acted to defend the 1979 Constitution from being overthrown, or he acted to restore the 1979 Constitution. And so he shouldn't be punished, or his punishment should be used against him to bar him from a political position. The court held that your punishment can be used against you because under the 1979 Constitution, there wasn't any protection for those who acted to restore the Constitution. That's why we've improved under the 1992 Constitution. So yes, under the 1992 Constitution, the improvement is that any Ghanaian citizen who acts to defend the Constitution, any Ghanaian citizen who acts to restore the Constitution, whatever loss you suffered, whatever liability you suffered, whatever wrong you suffered, whatever detriment you suffered, whatever criminal offense you've been punished for, right? When the Constitution has been restored, they are going to nullify that. I hope you got it. When the Constitution has been restored, they are going to nullify that particular wrongdoing. So it is very, very, very straightforward. I hope you got it. Very straightforward. So it means that Ghana does not practice the theory of discontinuity. Before we even come to theory of continuity, put that at the back of your mind. Ghana does not practice the theory of discontinuity. That's why in the NPP and Attorney General 31st December case, the court held that we are all under a duty to defend the Constitution, so we cannot even celebrate a coup d'etat with public funds. This means that we have a duty to restore the Constitution. There is no such thing as theory of continuity, discontinuity applied in Ghana. So just explain Kelsenite's theory of discontinuity and explain the Ghanaian position. Then you can also have a look at the Finnis's theory of continuity. According to Finnis, with his theory of continuity, a mere coup d'etat does not nullify the legal order created by the Constitution because there are three types of rules. Right, according to him, there are three types of rules. So he said, number one, there are rules of competence, rules of succession of office, and then there are also rules of succession of rules. So three rules: rules of competence, rules of succession of office, and rules of succession of rules. So with reference to the rules of competence, right, the rules of competence, what it means is that what makes you competent, right, to be in that particular position or to occupy that particular position, or what makes you competent in that particular position. So that is the job you must perform. You must be competent to perform that particular job. I hope you got it. You must be competent to perform that particular job. So that was explained in there by Finnis, the continuity theory. So more or less, that is the duties, powers, and functions that must be performed by the officials of government. So also we have the rules of succession of office. It sets up the office and how persons can occupy or succeed that office. So how do we replace the official? So let's say Ghana, we have rules of succession of office for even a president. A president can be removed from office. A president can be replaced. I hope you got it. Right. A president can be re-elected or his term will end and all that. So those are the rules of succession of office. I hope you got it. Right. So these are the specific rules that make you succeed that particular office. So it's just very, very straightforward. So there are the specific rules that make you succeed that particular office, right? And then there are the rules of succession of rules. So these rules provide for the change of rules under the legal order. So this is how the amendment is made. So under in our constitution, the rules of succession of rules are provided for. I hope you got it. Are provided for in the 1992 Constitution, Article 289 to 292. That is, what's the name? The amendment of the Constitution. So this is how the laws are changed. How one law can amend another law. I hope you got it. How one law can amend another law. So it's very, very, very straightforward. So these are the rules of succession of rules. So this means that according to Finis, when there's a mere coup d'etat or a change, an abrupt change in government, it doesn't necessarily breach the legal order. The legal order continues because usually the coup d'etat will just change the people who are the face of the government. Right. So they'll just change the rules of succession of office. These people are supposed to be maybe replaced by elections. But then how they succeed office is that they remove all of them by a coup and then they enter that office. But if you look at things closely, none of the laws are amended. The regular laws in the system, right? The laws of the legal order, none of them are amended or changed. They just comply with all of them and they'll just tweak some of them. So when there's a coup d'etat, what was a coup d'etat in 1966? Look at example, Ghana's position. We have the concept of existing law. How can we say the legal order has collapsed when we have existing law and Article 11? Look at the 1960 Constitution. That is, pardon me, the 1960 Criminal Act, 1960 Criminal Procedure Act, 1960 Contract Act, 1964 Sale of Goods Act. All these laws were passed by Nkrumah under the 1960 Republican Constitution. There was a coup d'etat in 1966, right? But what happened? What happened? Do you get the point? What happened? So what happened is that those laws are still applicable today. The legal order was not affected. The legal validity of those laws weren't, dependent on the coup or the authority of the coup at the time. That's the best example because Ghana enjoys the concept of existing laws that existed before the 1992 Constitution. They must simply conform with the 1992 Constitution. So the mere fact that there's an abrupt change of government doesn't destroy our legal order. All the systems, all the structures are still in place. You get it? So you compare Salah case and Lankami case. You know the issue in Lankami, right? They wanted to apply the Kelso-Knight principle, but the court held that what actually occurred was not a coup, but a mere transfer of government, a voluntary transfer of government from the transfer of power from the government, the people's government, to the military. So the military had not conducted the coup, so it could not be a breach or a breakdown in the legal order. That is that particular case of Salah and Lankami, the Lankami case. But in Salah and Attorney General, where his office was created by Nkrumah, right, under the relevant law EI 203, right. I think it is an executive instrument that established the particular state corporation under the State Corporations Act. So then Nkrumah had established that office. Then there was a coup. Then Salah was appointed into that office. So when the 1969 Constitution was passed, it was stated that all those persons, all those people whose offices were created by the National Liberation Council, they'll just be there for 6 months and they'll be removed. But the court held that no, Salah's office is not part. His office was not created by the National Liberation Council. Now, the Attorney General was arguing that his office was continually enforced by the National Liberation Council. No, the office got its legal validity from incumbent law, that is the State Corporation Act and the EI 203. So you can't say that it should be given a technical meaning. I hope you got it. Right. The new office the change of government didn't create a new legal order. So I refer to the Salah and Attorney General case. I refer to the Lankami case. I also referred to the NPP and Attorney General 31st December case. And I refer to the Ekwam and Penim case. And there are other authorities that are in there that you can make reference to. I hope you got it. And we have important points like the advantages and disadvantages of each theory, which is likely to come. So I've updated the drive with those particular information. So let's move on. So let's have a look at the next point, right? So you are going to have a look at, so you are done with the theories. Now we are going to have a look at the major organs, and it's going to be very straightforward. Very, very straightforward, because we've dealt with the foundations of it. You got it. We've dealt with the executive, the legislature, and the judiciary. So let me give you some highlights of the major organs. For example, the executive. The executive power is created under Article 57 and Article 58 of the 1992 Constitution. So Article 57 provides, Article 57 of the 1992 Constitution provides that the President of Ghana is the head of state, right? And also the head of government, and also the head of the Ghana Armed Forces, the Commander-in-Chief of the Ghana Armed Forces. His office shall hold precedence over the Vice President, the Speaker of Parliament, and also the Chief Justice in that particular order. So make reference to the case of Professor Asari and Attorney General. That is the swearing-in case, where I explained that when the President and Vice are out of the country, it is presumed that they are unable to perform their functions. So once they are unable to perform their functions, they are replaced by the Speaker of Parliament. It's a very straightforward case. So in this particular case, it shows you that there must always be an executive authority in Ghana, or a representative of the executive authority in Ghana. So the executive is represented by the President and Vice. But if they are both out of the country, or if they are both unable to perform their functions, they are replaced ceremonially by the Speaker. So usually, according to Dateba, the Speaker will only perform ceremonial functions until the President or Vice returns, or if something happened, maybe they are both dead or something, within a short period of time, they will hold elections. I hope you got it. Right, so that is the straight forward point in there. So it's very, very, very straightforward point. Right. So we are going to have a look at Article 58. Article 58 of the Constitution is also very important. Remember Article 58. It states that the function of the executive is to execute and maintain the Constitution and all the other laws of Ghana. So anybody that is in charge of executing the laws, that is exercising the authority of the law, implementing the law, is part of the executive. So all the ministries, right? All the ministries, if they pass a law pertaining to children, right? The Children's Welfare or the Children's Act, right? There'll be a ministry in charge for that particular execution of the law. If they pass a law relating to what affirmation, affirmative action, there'll be a ministry in charge of the execution of the law. If they pass a law relating to education, if they pass a finance law, there'll be a ministry in charge of those laws. So those ministries implement the laws. Those administrative bodies implement the laws. The state corporations, they are implementing the law, because all state corporations are created by statutes. You get it? So anybody that implements the law is under the authority of the president. That's why the president, appoints the head of the state corporations, and the president appoints the head of the administrative bodies. You get it? So you have to understand the full list of administrative bodies in Ghana. I hope you got it. Right. So just give some examples of the administrative bodies in Ghana, like the Public Utilities Regulatory Commission, the Food and Drugs Authority, right? The Food and Drugs Authority. We have the Ghana Police Service, the Ghana Prison Service. So those are under the Ministry of Interior. The Ghana Police Service, the Ghana Prison Service, the Ghana Immigration Service, the Ghana Ghana National Fire Service. Under the Ministry of Health, we have the Food and Drugs Authority. Under the Ministry of Trade and Industry, we have the Ghana Enterprises Agency, the Ghana Export Promotion Authority, the Ghana Free Zones Authority. I hope you got it. Under the Ministry of Finance, we have the Ghana Revenue Authority, the Controller and Accountant General's Department, the Public Procurement Authority. I hope you got it. Right. So there are also regulatory institutions, National Communications Authority, NCA, right? National Peace Council, Ghana National Service Secretariat, that organization, Ghana Health Service, Ghana Education Service, right? The Bank of Ghana. There are other key bodies like the Bank of Ghana, the Security and Exchange Commission, the Ghana Cocoa Board, the National Identification Authority, Drivers and Vehicles Licensing Authority. All these administrative bodies, they administer or implement the law. So they are under the executive authority of the president under Article 58. So that's why the president is the one who appoints the heads of this particular body. And some of them have special functions under Article 70. They are called the Article 70 office holders. So if you look at the 1992 Constitution of Ghana, right, you see under Article 70 a list of Article 70 office holders under the 1992 Constitution. These particular office holders are appointed by the president. I hope you got it. So let me just give you the list of Article 70 office holders. So we have number one, the Auditor General. So if you look at the Auditor General, number one, the Commissioner for Human Rights and Administrative Justice and his deputies. So SRAJ, Commission for Human Rights and Administrative Justice, right? SRAJ, they are in charge of reviewing the actions of administrative bodies and ensuring that they are not corrupt or they are not abusing their powers or infringing upon human rights. So that is SRAJ. Then we also have the Auditor General. So for the Auditor General, pay attention to this case. Center for Democratic Development, right? That is the CDD versus the Attorney General. In this particular case, the former President Akufo-Addo directed the Auditor General to go on mandatory leave. The court held that the Auditor General is a special office. Although you appoint the Auditor General, you don't have the right to infringe or interfere with the independence of the Auditor General. So you can check that. I think that's Article 187 of the 1992 Constitution. So we also have, it says the District Assembly's Common Fund Administrator, Public Office, the Chairman and other members of the Public Services Commission, the Lands Commission, and the governing bodies of public corporations. So public corporations, all the public corporations. So remember, there's also the addition of the Special Prosecutor. It's a special office, like Article 71. This was dealt with in the case of Dominic Ayini and the Attorney General. I repeat, Dominic Ayini and the Attorney General. I repeat a third time, Dominic Ayini and Attorney General. And a fourth time, Dominic Ayini and Attorney General. So in this particular case, the court held that the special prosecutor, right, is not subject to the retirement age of a general public servant. That is 60 years. No, the special prosecutor, the office of the special prosecutor is a special office. He is specially appointed by the government or the president to appoint a special rule. He falls under Article 70. So these ones, they are not interfered with, they are not supposed to be interfered with in the performance of their functions, and they are not subject to the general rules of the public authorities, right, or the public servants. So who are the public servants? Under Article 297, the law says that, under Article 297 of the 1992 Constitution, it is clearly stated that whoever more or less appoints the public servant or whoever appoints someone, Article 297, has the implied authority to remove or discipline the person. You get it? Right. So look at the CDD case. The court held that no, this particular provision does not apply to what? Special office holders. I hope you got it. This particular provision does not apply to special office holders. So it's a very, very, very straightforward point. So that's under Article 297 of the 1992 Constitution. And then you can use the case of Dominic Ayini and Attorney General, and also the case of Center for Democratic Development against the Center for Democratic Development against the other, that's the Attorney General. I hope you got it. So it's very straightforward. So it means that any person that is directly appointed by the president is a special public office holder. The heads of the public operations under Article 70, or the heads of special public corporations, under Article 70, the SRAJ, the electoral commissioners, they are all appointed by the president under their relevant provisions, the Auditor General, and pay attention to the two cases I've mentioned. Then also the president, if you remember, is the one who appoints the ministers under Article 78, but they must go through vetting and approval by Parliament. So the president appoints the ministers, but they must go through vetting and approval by Parliament. The case of J.H. Mensah and Attorney General, I've already explained it under Article 78. Now remember, per the case of Professor Sari and Attorney General, that is the swearing-in case. Remember what I said, that when the president and vice are out of the country, they are usually deemed to be performing their functions abroad. For example, they are representing the state interest abroad. So they are entering into negotiations on behalf of the state. They are joining meetings, the UN Council meetings, the UN General Assembly meetings, international body meetings, etc. So in this particular cases, right, the president can enter into treaties or agreements on behalf of the state, or the delegates of the president, or those who act under the authority of the president can enter into what? They can enter into what's known as Oh, well, then I just lost my train of thought. So those who act on behalf of
Oh,
the
the tap is not
right,
flowing.
they can enter
Hey.
into agreements or treaties on behalf of the state. Can you mute the person? I'm being distracted. So they enter into treaties on behalf of the state under Article 75. And when they enter into such treaties, right, there is a need for ratification. Now, the president, if you look at Article 125 of the 1992 Constitution, right, and Article 127, the effect is that the judiciary cannot be interfered with in the performance of their functions, and the judiciary has final judicial power. But whatever conviction that the judiciary give, right, sentence, right, under Article 72 of the 1992 Constitution, the president has what is known as a prerogative authority. The president has what is known as a prerogative authority. So that's the prerogative of mercy, the prerogative power of mercy. So this means that the president can grant, can basically pardon someone or reduce the sentence of the person under Article 72. Pay attention to this relevant case, the case of Eliplim Abemava and the Attorney General. Right, you can go and have a look at the principle. It's a very interesting case. So the president, right, has the prerogative of mercy authority under Article 72. The president enters into treaties, they must be ratified by Parliament under Article 75. The president appoints the ministers under Article 78. The president appoints the head of the Ministry of Justice, that is the Attorney General, under Article 88. So the Attorney General is the principal legal advisor of the government, but he also implements the law. He also initiates all criminal proceedings on behalf of the state, and he also represents the state in all civil proceedings. He is the state legal advisor. He is appointed by the president under Article 88 of the 1992 Constitution of Ghana. So under Article 88, based on that authority to initiate and conduct all criminal proceedings, the Attorney General cannot be directed on how to initiate and conduct criminal prosecutions. This is a very, very important matter. And pay attention to the case of Gregory Afoko and Attorney General dealing with non-imposed crime, and the case of Dr. Forson and Attorney General. All the briefs are in the materials that I've been sharing on the Google Drive. But basically, the point is that the Attorney General can enter non-imposed crime, right? And he doesn't need to provide a reason for the entry of non-imposed crime. It is his discretionary authority. Under Article 296, right? If you're exercising discretionary authority, you just have to be fair and candid. So it's his discretionary authority. I hope you got it. Right. So he doesn't need to provide a reason for the entry of non-imposed crime. It doesn't need to provide a reason for the entry of non-imposed crime. So it's just a straightforward point. Right. Then also under so we dealt with Article 88, Article 72, Article 75, Article 78, Article 70, Article 60 clause 11 deals with Professor Attabi and Attorney General. Are you getting it? So Article 57, Article 58, Article 60, Professor Asari and Attorney General. Article 57, the president is immune because he holds the presidential authority. So he's immune from suits. We have the case of MPP and Wallins that I already mentioned, the case of Amidou and Kufuor that I already mentioned, and also the case of Bilson and Wallins that I already mentioned. I already mentioned Professor Asari and Attorney General for Article 60 clause 11. And I also mentioned for Article 70 office holders, Center for Democratic Development and Attorney General. And then we also have the case of Dominic Anyini and Attorney General. And then we also have another matter dealing with Article 72, Eliplim Abemava and Attorney General. Then we have Article 75, Margaret Banfo and Attorney General. Then we also have Article 78, J.H. Mensah and Attorney General. Then we also have Article 88, Dr. Forson, Republic and Dr. Forson. You can have a look at the brief that we've uploaded on the Google Drive with how to address such a question. And then, Gregory Afoko and the Attorney General. So the brief is also in there. So now we are moving on to the legislature. Right. I'll finish before very pretty soon. So we are moving on to the legislature. So now, legislature. So the legislature is the authority that has been vested with the power to pass laws. It has been vested with the legislative authority. So there are multiple types of legislative authority. Right. Now, this is the power to pass statutes under Article 106 of the 1992 Constitution. And I told you that under Article 106, right, there must be an explanatory memorandum. And I used the case of Ezwame Manan, an Attorney General, for explanatory memorandum. Ezwame Manan, an Attorney General, for explanatory memorandum. I also stated that there must be assent by the President, and I referred to Amanda Odoye, an Attorney General, and Richard Sky, an Attorney General. You have to read those cases very well, especially the briefs and the principles in those cases. But those are the landmark authorities that if the bill is not assented to by the President, it cannot become a law. You get it? And then we move on to the fact that in the lawmaking process, there must be reference made to the National House of Chiefs if it is a law affecting chieftaincy. And I made reference to Wari and Oforiata. I hope you got it. And I told you about the quorum for the passage of laws. And I made reference to Justice Abdullah. So you can have a look at the principle in that case, which is also on the drive. But more or less, it's very important to note that the parliament does not only exercise legislative authority to pass statutes, they also have legislative authority over treaties. That when a treaty is passed by the president under Article 75 or a convention has been executed by the president under Article 75 of the Constitution, it must be submitted to parliament for approval. That is ratification. Under Article 75 of the 1992 Constitution, that is a very, very, very straightforward point. Article 75 of the 1992 Constitution, very straightforward point. So that is a treaty, ratification of treaty. So apart from the regular lawmaking authority, the statutes, Parliament also ratifies treaties. And Parliament also passed legislative instruments under Article 11, Clause 7 of the 1992 Constitution. So under Article 11, Clause 7, it says that a legislative instrument must be brought before Parliament for approval. But a legislative instrument, subsidiary legislation, subsidiary legislation must be brought before Parliament for approval. So Parliament can also decide to reject it, but they cannot amend it. And I made reference to the case of Okwemwe versus the Electoral Commission. And then remember, the law that comes before Parliament must be under the legislative authority of Parliament. So if you bring an executive instrument and it's not legislative in nature, then it is wrong. You cannot bring an executive instrument under Article 11, Clause 7 for Parliament to approve it. No, executive instrument is an execution of the authority of the executive. So this was explained in the case of Bafo Ose Akoto and Attorney General. I gave the full facts and principles and briefs in there and the breakdown of the brief. But the point in the Bafo Ose Akoto, right, case is that where there's an executive instrument, it's not mandated for the executive instrument to be brought before Parliament under Article 11, Clause 7 for approval. That is it. So you see, Parliament are also entitled to certain immunities under Article 115 to 118 or so of the 1992 Constitution. So let's have a look at Article 115. It says freedom of speech and proceedings. There shall be freedom of speech, debate, and proceedings in Parliament, and that freedom shall not be impeached or questioned in any court or place out of Parliament. So you can have a look at the three cases that I mentioned, especially for immunity of MPs and the Speaker. The first and the most important case that I gave to you was the case of Tufor and Attorney General, and the brief has already been uploaded, and I already explained the principle in that case. The second case that I gave to you was the case of Samoku Jeto against Reverend Kusi Boateng, and I already explained that when a parliamentarian is on his way to Parliament or his way out of Parliament, what basically happens is that he cannot be served in judicial proceedings. This is provided for under Article 117 of the 1992 Constitution. Civil or criminal process coming from any court or place out of Parliament shall not be served on or executed in relation to the Speaker or a member or the clerk to Parliament while he is on his way to attending at or returning from any proceedings in Parliament. I hope you got it right. So it's a very, very, very straightforward point. Very, very, very straightforward. Right? Very straightforward. Do you get it? So you realize that yes, parliamentarians are also immune, but it is limited immunity. I hope you got it. It's limited immunity, and they are immune from publication of proceedings. They have privileges as witnesses, privileges of witnesses, but there are criminal proceedings that can happen against parliamentarians. I hope you got it. And general contempt under Article 122. So the fact that you are immune doesn't necessarily mean that you should abuse your powers under the Constitution. No, you can actually be faced with contempt of Parliament, right? So That is the point in there. So I gave Honorable Afenyo Makin and the Attorney General for this general case of immunity. So the Speaker of Parliament is immune from being personally attached or having personal liability for the performance of his job as a parliamentary, as the Speaker of Parliament, right? So it's very, very straightforward. Now let's also have a look at certain important principles under the qualification of parliamentarians. I hope you got it. Under the qualifications of parliamentarians. So what are we going to look at? We are going to look at number one. Let's read Article 94 of the 1992 Constitution. Very important. Article 94 of the 1992 Constitution. So parliamentarians, it says under Article 94, qualifications and eligibility. So subject to the provisions of this article, a person shall not be qualified to be a member of parliament unless he's a citizen of Ghana, has attained the age of 21 years, and is a registered voter. The case in point for this particular provision is ex parte Zanito Rawlings, where the court held that although she was not a registered voter at the time of the parliamentaries, what do you call it? You know what I'm talking about? The primaries, right? So although she was not a registered voter at the time of primaries, by the time she nominated herself to contend for the MP position of that particular constituency, right? She had a she was a registered voter. So the point is that these particular qualifications must appear or must be in existence at the time that you are nominating yourself for the position of an MP candidate, a member of parliament candidate, or a parliamentary candidate. So at the time that you are nominating yourself for the particular position of a parliamentary candidate, you have to make sure that you are, number one, above the age of 21 years, number two, right, you are a citizen of Ghana, and number three, you are a registered voter. So you must be above the age of 21 years, you must be a citizen of Ghana, and you must be a registered voter. I hope you got it. So you're above the age of 21 years. You must be a citizen of Ghana, and you must be a registered voter. I hope you got it. Yeah, a registered voter. So that's the point in there. So you realize that this was explained in the case of ex parte Zanito Rawlings. So pay attention to that case. The full brief and the relevant holdings have already been stated in the drive. I'm just supposed to give the principle because of the time element. So we are going to move on to another important aspect, right? Under Article 94, it says that the person shall not owe allegiance to so he's resident in the constituency, blah blah blah. He has paid all his taxes, blah blah blah. So Article 94, Clause 2. A person shall not be qualified to be a member of parliament if he A owes allegiance to a country other than Ghana. So you can be a dual citizen, but for membership of parliament, you cannot owe allegiance to any other country. So a dual citizen is presumed to owe allegiance or loyalty to another country. This was explained adequately in the case of Michael Nifa and James Chachi-Quayson. I explained the difference between allegiance and loyalty and citizenship, right? And I stated that already a dual citizen, right, cannot be deemed to owe allegiance. A dual citizen is deemed to owe allegiance to the other country. So, per the implication of Article 8 of the 1992 Constitution, when you're a dual citizen, you cannot nominate yourself to be a member of parliament. Remember the ex parte Zanito Rawlings case, that the nomination occurs at the time of, the qualification must exist at the time of nomination. So at the time of nomination, he was still a dual citizen, although he had taken steps to revoke his Canadian citizenship. At the time of nomination, he was still a dual citizen. So Michael Nifa and James Chachi-Quayson. We also have the is it the Sumaila Bible case? You can also have a look at that, but that's just a supporting case. Then we also have, you have not been adjudged or otherwise declared bankrupt or to be of unsound mind or convicted of a high crime, right, under this constitution or high treason. So for this particular case, that is the I, you can look at the case of Ekwan Mpieni. In the case of Ekwan Mpieni, right, he was going for a political office, right? And this provision, he needed to qualify, but then this provision stood against him because in reference to this provision, he had been arrested under the PNDC for trying to, according to him, restore the constitution. So he claimed that this provision can't stand against him because he was acting to restore the constitution. But the court held that that was the 1979 constitution, not the 1992 constitution. So, unfortunately, this provision worked against him. So, if you've been convicted of high crime or high treason or for an offense involving the security of the state for dishonesty or moral turpitude, or any other offense punishable by death or by a sentence of not less than 10 years, or for an offense related to or connection with election under a law in force in Ghana at any time. So this case, right, is the Sumaila Bible case. So he was convicted of an offense relating to this one was in perjury. I hope you got it. Perjury. So more or less, what happened was that he lied to the electoral commission that he was not a dual citizen. I hope you got it. He lied to so that is the Sumaila Bible and Adamu Dramani, right? So he lied to the electoral commission that he was not a dual citizen, when in actual fact he was still a dual citizen. So he was even arrested and imprisoned for perjury. You get the point. So it's very, very straightforward. So more or less, if you've been arrested for an electoral offense, it's very unlikely that you can stand the chance of being a member of parliament. I hope you got it. Right. So it's very, very straightforward. Now, if you look at the relevant provisions in there, you see I've given you a lot of cases, and most of the cases you are supposed to know them offhand. You are supposed to know them by heart. They must be in your heart, because the question can come from anywhere, but they'll be based on these important provisions and these important cases. The examiners are not going to give you something strange. They are not going to give you something out of the blue. It will be a straightforward, foundational essay question or problem question. Just make sure that your authorities are sound. Just make sure that your authorities are sound. That's why for the legislation, you know that there's a way to structure your authorities to trace from the original, the original foundation of the constitutional principle, all the way to the foundation of that particular theory, all the way to the application of the exact subject matter provision of the Constitution, all the way to the relevant cases. So you might think that, for the removal of the Chief Justice case, I just need maybe Ghana Bar Association or maybe Honorable Justice Tokonu. But another student who has understood this principle of breaking and creating up a structure will know that you have to start from somewhere, establish the principles, come all the way to the particular theory or doctrine that applies to the subject matter. Then you break it down to the particular provisions and cases that directly apply to the subject matter. So by the time the student comes to Honorable Justice, Chief Justice Tokonu and Attorney General, the person has already given over 6 articles, 6 cases before he comes to the subject matter principle. You get it? Because constitutional law is a story, it's a foundation. You need to start from the original principle. So I started from somewhere before I'm coming to the actual principle. So you realize that by the time I reach executive, legislature, and judiciary, I'm just repeating some of the cases. And every case I've repeated is a landmark case. Let's continue. So matters dealing with the speaker, the deputy speaker, and all that. You can also look at, if you look at treason, you can look at Republic and Dr. McPalm. That's a landmark case for treason. So basically, some of the accused persons were convicted of treason. I hope you got it. Right. You cannot also be eligible to be a member of parliament if you're a chief. Very, very, very important. You are not eligible to be a member of parliament if you're a chief. So we'll come to chieftaincy later. It will be one of the last points we deal with. Right. So basically, the third, matters dealing with quorum in parliament, I've already treated it under Justice Abdullahi and Attorney General. So you are going to have a look at another important matter, that is the judiciary. You get it? So you see, we are looking at the arms of government. So when you come to the judiciary, it's very straightforward. The judiciary is also an arm of government that has been vested with authority to adjudicate, interpret the law, and also apply justice. I hope you got it. So they carry the sovereignty of the people in reference to the application of justice. So that is the judiciary of Ghana, right? That's the judiciary of Ghana. So in that particular sense, how do we break down the elements of judiciary? So because of the time, I need to close in about 15 minutes. So because of the time element, I'm going to have a look at the judiciary. Just a moment. So I'll just go through it quickly. So basically, the judiciary is created under Article 125 of the 1992 Constitution, right? So Article 125 of the Constitution says this, and I read, and I'll just give you some landmark authorities. Justice emanates from the people and shall be administered in the name of the Republic by the judiciary, which shall be independent and subject to this Constitution. So as I already said, the judiciary of Ghana shall have jurisdiction in all civil and criminal proceedings. Right, it is headed by the Chief Justice. I hope you got it. Under Article 127 of the 1992 Constitution, the judiciary is what is vested with final judicial power. I hope you got it. And the judicial officer, that is the Justice of the Superior Court, or anyone exercising judicial power, shall not be liable to any action or suit for any act or omission by him in the exercise of the judicial power. I hope you got it. Right. So the judiciary is independent. So they pass, decisions, they exercise their mandate independently. They are only subject to the Constitution. So apart from what the Constitution specifically provides for, the judiciary is independent. So obviously, in the appointment of the judges, right, the judiciary cannot be independent because the Constitution provides for checks and balance, right, separation of powers, and also constitutionalism, certain limitations. So the president must act in consultation with the with the Council of State, right, and with vetting and approval by Parliament, appoint the Chief Justice, right. So in that sense, you can look at the cases I've already mentioned. Have you seen Ghana Bar Association and Attorney General, Tufo and Attorney General, right? We also have Ghana Bar Association and then the Amegecha and Attorney General. I've explained all these cases earlier during this class, and the full cases, the briefs, and the provisions have been made available on the Google Drive. So more or less, the principle, especially for the Judicial Council, that is dealing with the appointment of Supreme Court judges, a similar process. So the appointment of a judge and the removal of the judge, their salaries and emoluments, right, as well as certain other things that are specifically provided for by the Constitution, right, are applicable and they override the independence. So although the judiciary is independent, it is subject to the Constitution. So if the Constitution specifically provides for something, then the judiciary, right, cannot claim independence over that particular thing. And so in one of the previous sessions that I did, I had an entire review of judicial independence, an entire review of the judicial structure and the application of judicial independence, because looking at the Chief Justice case, that is the Honorable Justice Tokonin case, right, you could realize that there are a lot of questions pertaining to judicial independence, and it's a trending matter. So I think that particular article is very important. So I think I've also uploaded it on the Google Drive. But the point is that the judiciary, so how to address that question if it pops up, there's a structure to it. You get it? There's a structure to it. You need to start from the foundation and then you need to break it down. So the judiciary is basically independent by what? In the appointment and the removal of the Chief Justice and the justices of the Superior Court. They are not independent. So what I'll do to help you is to read out the full provision under Article 146 of the 1992 Constitution. And then, because of the time element, I'll just state the relevant cases, right? Or I'll just read it out. So a justice of the Superior Court shall not be removed from office except for stated misbehavior or incompetence on ground of inability to perform the functions of his office arising from infirmity of mind or body. So number 2, a justice of the Superior Court of Judicature or a chairman of the regional tribunal may only be removed in accordance with the procedure specified in this article. So once they've complied with the procedure in Article 146, then the removal is valid. If the president receives a petition, so it means that the president, right, should not interfere with the independence of the judiciary unless the Constitution expressly provides for it. So it says if the president receives a petition for the removal of a justice of a Supreme Court other than the Chief Justice or for the removal of the chairman or so other than the Chief Justice, he shall refer the petition to the Chief Justice, who shall determine whether there's a prima facie case. And in the case of Ejechum and Attorney General, the court held that if the matter is for the removal of the Chief Justice, then the president cannot refer the same matter to the Chief Justice to determine a prima facie case. So the president will refer the matter to a committee. I hope you got it. So you create a committee and refer the matter to the committee. So when the committee decides that there's a prima facie case, then they shall set out, the president shall set up another committee appointed and with some members appointed by the Judicial Council, etc. And certain persons to make up the committee, and the committee shall investigate the complaint. That is basically it. And the committee will make recommendations. So you see, the outline of the procedure is under Article 146. I advise you to read Article 146 very well, because it's an important provision. Do you get it? So more or less, right, if the president is able to comply with the process provided for under Article 146, then the removal is valid, although you cannot interfere with the authority of or the independence of the judiciary. As long as you act in conformity with the process, then it is valid and it is binding. So you can have a look at the case of Honorable Justice Derry and Attorney General, Ghana Bar Association and Attorney General, Justice Abam case, and then the Honorable Tokonu case. And then that is it. I hope you got it. Right. So basically, because of the time element, let me just decide to deal with some other organs. Right. So I'll deal with the committees of inquiry. Right, I'll deal with the committees of inquiry or the commission of inquiry. Right, so I'll just go over it quickly and I'll give you some relevant cases. So for the commission of inquiry, pay attention to Article 278 Clause 1 of the 1992 Constitution. Right, it says the president may set up a commission of inquiry to investigate matters of public interest. Such commissions, though non-judicial bodies, are quasi-judicial in nature, and they are powered under Article 279 to summon witnesses, compel production of documents. So basically, it must be a matter of public interest, right? A matter of public interest. So a matter of public interest is any matter that inures to the benefit of the public. It is any matter that inures to the benefit of the public under Article 295 of the 1992 Constitution. So it inures to the benefit of the public. So it's a matter of public interest. So the president can at any time set up this particular commission of inquiry to investigate the matters of public interest. So although they are not courts, because under Article 126, there are two types of courts, are the superior court and then the lower court. So the superior court is the Supreme Court, is the Court of Appeal, as well as what is known as, so we have the Supreme Court. The Superior Court refers to the Supreme Court, the Court of Appeal, and also the third one being the High Court. I hope you got it. But the inferior court also refers, the lower court under the Courts Act refers to the what? The Circuit Court and then the District Court. So those are courts. So the Commission of Inquiry is not a court. So I'll come to that. So because the Commission of Inquiry is not a court, they have limited authority, but they still have the authority to summon witnesses, compel production of documents, and make findings of fact. So they do not make what? They do not determine matters of law. They only make findings of fact. Remember, the court, if you look at the Courts Act, right, the court can make determinations of matters of law. If you look at the matter of judicial precedent, which I've uploaded dealing with Ghana legal system, judicial precedent, I explained clearly that judicial precedent under Article 129, let's say the Supreme Court, the binding matters are matters of what? So we have matters of court, and then we also have matters of law. So the binding precedent are on matters of law. They are on matters of law. Do you get it? They are matters of law. So those are the binding precedents. They are matters of law. So they are not matters of fact. I hope you got it. Right. So you have to pay attention to that. So because the court determines matters of law, the Commission of Inquiry cannot determine matters of law. They can only determine matters of fact. So it's like a fact-finding commission or committee. Pardon me. Look at the case of ex parte Bannerman, where the Committee of Inquiry decided that they found certain facts of stealing against Mr. Bannerman. So they sacked him from office. Can you imagine? Right? The court said that no, you do not apply the law. You just find facts. So what happens when they find the facts? The facts must be submitted to the president. So the white paper or the recommendations or whatever evidence or facts they gathered or whatever opinion they have must be communicated to the president. Right. So they have the authority or the duty to make a full, faithful, and impartial inquiry into any matter. Remember the principle of natural justice. So if any member of the committee investigating someone is in a relational connection with a particular person or has a pecuniary interest in the matter or is biased, then it will not be fair under Article 280 because you must be impartial. I hope you got it. Then, yeah, where the report of a commission of inquiry is submitted to the president, I hope you got it. The president shall cause to be published the report together with the white paper within 6 months after the submission. I hope you got it. And then later on, the president can give reasons why the report is not to be published. Right. So the finding of the commission of inquiry is not a judgment. It shall not have the it shall not have the effect of a judgment of the High Court unless 6 months have passed after the finding is made and announced to the public. Right. So that means that within the 6 months, you can actually bring an action to appeal that particular judgment. I hope you got it. Within the 6 months, you can actually bring an action to appeal that particular judgment. I hope you got it. Right. So when you don't bring an action to challenge it, right, it can hold against you. Remember the case of Bedema and Awuno Williams. The commission of inquiry made a finding against him that he was basically corrupt. The court held that once you are corrupt, or once there's a finding that you are corrupt, then it can hold against you. Other relevant cases on commission of inquiry that I've explained are the case of Republic versus Wilkie, Bobe, and Impieni. It's known as the Ghana at 50 Commission of Inquiry case. Right. So there are certain important findings in there. You can also look at the case of Reappenting. Right. In Reappenting, the court held that recommendations of a commission of inquiry is not a criminal prosecution, but they can lead to a criminal prosecution. So the prosecutors can rely on the commission of inquiry to make a determination as to whether to initiate a criminal prosecution. The committee of inquiry cannot punish you for any criminal offense. They can provide a foundation for the criminal offense to be made and for the criminal charges to be brought against you. So they are the foundation. So they to be referred to the Attorney General for him to, based on the findings of the Commission of Inquiry, release, bring charges against you. I hope you got it. All right. So let's quickly move on to the next topic because I'm quickly going through the minor organs. So I'm just wrapping up because I need to finish by 10. So another minor organ is the Auditor General. Right. So let's have a look at the Auditor General in finance. So for the Auditor General, you have to understand what it means to have what the consolidated fund means and the public funds of Ghana. So generally speaking, the public funds of Ghana under Article 175 are the consolidated fund, the contingency fund, and any other fund that is established by the government under an authority of an act of parliament. So the consolidated fund, all the revenues and other monies raised or received by the government goes into the consolidated fund. And then the contingency fund is advances made, right, by the authority of parliament, right, for certain future urgent or unforeseen expenditures. I hope you got it. Right. So for the authorization of the expenditure, the president shall lay before parliament at least 1 month before the end of the financial year estimates of the revenue and expenditure of the government of Ghana for the following financial year. You get it? So more or less, pay attention to those particular provisions. So anything dealing with public finance, it comes under the authority of the Auditor General. What the Ministry of Finance, under the authority of the President, that is the executive, their main rule is to ensure that, number one, the budget, right, is well prepared for the next financial year, is presented before Parliament for approval. I hope you got it. Even when we are entering into international business or economic transactions, have a look at the case of Attorney General in Balkan Energy. I fully briefed the case and I explained the principles of those cases in the Google Drive. But basically, if there is an international business transaction, it must also be brought before Parliament because it deals with international finance and Parliament must have a say. That is, I think, I need to confirm, but I think it's Article 185 or something of the 1992 Constitution. But then also under Article 187, that's the authority of the Auditor General. So it says that the Auditor General's office is a public office. The Auditor General's office is independent, right, from interference of the president and any other person, apart from what is expressly stated by the Constitution, right? So also the Auditor General has the authority to review and audit all the accounts of the public institutions and the government administrations and the central government bodies. So you review all the public accounts, all the accounts, and then if you even see suspicious activity, you can make a report and can refer it to the necessary authorities to take action. So it says under Article 187, Clause 7, in the performance of its functions under the Constitution or any other law, the Auditor General shall not be subject to the direction or control of any other person or authority. So with reference to the Auditor General, you are looking at what? Article 187, especially the independence of the office of the Auditor General. You are looking at the case of what? CDD, the Center for Democratic Development against the against the Attorney General, so against the AG. So in this particular case, the court held that although the president appoints the Auditor General, and under Article 297, it is implied that the person who appoints also has the power to move or direct or exercise disciplinary control over another particular body. Yeah, the Auditor General has been specifically stated under Article 187 to be an independent office. And so, although the president has authority over all public officials, he doesn't have authority to direct and interfere with the functions and the execution of the authority of the Auditor General. That was established in the Center for Democratic Development against the Attorney General. And this dealt with the directive that the president gave to the Auditor General to go on mandatory leave. That was former President Akufo-Addo, and then the Auditor General was the former Auditor General Domilovu, right? So he directed him to go on mandatory leave. The court felt that amounted to an interference with the authority of the Auditor General. I hope you got it. So it's very straightforward. So that is the landmark principle. So the Auditor General is also a special office under Article 70. So in reference to Article 70, remember the landmark is I gave Dominic Ayini and Attorney General. So the full brief has already been provided. So he audits all those particular bodies, and then he basically gives recommendations or make sure that there is no abuse of public funds. So whatever budget you provided, whatever money you are receiving, whatever transactions, I hope you got it right. They must be audited by the Auditor General so that they are consistent. I hope you got it right. So it's a very straightforward point. I think I'm even getting tired. Let's wrap up. So let's have a look at another important minor organ, SWAJ. That is the Ombudsman. Article 216, Commission on Human Rights and Administrative Justice. Just put that at the back of your mind. So what is the purpose of SWAJ? So the purpose of SWAJ is under Article 218 and also the SWAJ Act. You don't need to memorize the SWAJ Act provisions. Just say under the SWAJ Act. What you need to memorize are the constitutional law provisions. Just understand that SWAJ has two main functions: to usually investigate complaints or violation of human rights, because it is Commission of Human Rights and Administrative Justice. So violation of human rights and freedoms, abuse of powers, unfair treatment, right, and also any instance of alleged or suspected corruption and misappropriation of public funds. So that is it. Now, SWAJ doesn't have the authority to prosecute you, but SWAJ has the authority to investigate and bring actions. I hope you got it right, because SWAJ is a government body. So in the case of SWAJ and Ghana National Fire Service, they realized that the Ghana National Fire Service was discriminating against certain women who got pregnant. So SWAJ, that is the Commission of Human Rights and Administrative Justice, in order to protect the human rights of the people, brought an action against the Ghana National Fire Service for a declaration that what they did was discrimination and for the payment of damages. I hope you got it. So that is SWAJ against Ghana National Fire Service. So corruption of a public officer is defined as a criminal activity under Section 239 of the Criminal Act. It says a public officer who commits corruption or willful oppression or extortion commits a misdemeanor, and a person who corrupts any other person in respect of a duty as a public officer commits a misdemeanor. So that particular offense under Section 239 was so small those days, 1960, that if you commit corruption, it's a misdemeanor. A misdemeanor is a petty offense. You see, Nkrumah was a very straight individual. He didn't expect corruption to go this far. You get the point. Now, corruption is a serious issue in Ghana, and so there's likely to be a trending matter. It's likely to be a trending matter. The corruption issues and the office of the special prosecutor. I'll come to that. So with reference to corruption, which is a trending matter, you need to know the history. In 1960, when they're passing the Criminal Act of Ghana, Act 29, right, Section 239, right, it provided that a public officer who is corrupt or commits extortion commits a misdemeanor, a petty offense, right? So later on, the amendment was made in Section 179 after the passage of the 1992 Constitution. Over 30 years later, the amendment was made and they had Section 179A. It says, under Section 179C, pardon me, using public office for profit. So a person commits a criminal offense who, whilst holding a public office, corruptly or dishonestly abuses the office for private profit. Are you getting the point? So in the 1960s, when the Criminal Act was passed, right, what happened was that they didn't expect corruption to be a serious offense, so they stated it was a misdemeanor. So later on, after 1992, when corruption had come to stay, right, and became a serious issue in Ghana, they needed to let the Criminal Act reflect the punishment, right? Because of the fact that under Article 19, Clause 11, you cannot be guilty of a particular offense unless it is written with law with the punishment prescribed. The punishment prescribed for corruption was a misdemeanor. So now they increased it to be what? A serious offense. So it says that the penalty. So a person convicted of a criminal offense is liable to a fine of not less than 250 penalty units or a term of imprisonment not exceeding 10 years or both. So you can have a look at the Republic versus Ibrahim Adam, where the court explained even causing financial loss to the state. So it says under Section 179E, right, a person causes financial loss to the state through his action or omission. He intended to end or desire to cause the loss, also foresaw the loss as virtually certain and took an unjustifiable risk of it, and foresaw the loss as a probable consequence of its act and took an unreasonable risk. So you can have a look at the Republic and Dr. Forson case. I mentioned it in relation to the Auditor General and the Attorney General, right? So the Attorney General, if you hear that particular matter, was basically trying to make sure that the criminal trial proceeds in a particular way. So apparently, one of the accused persons claimed that the Attorney General was making contact with him so that he'll be able to lead evidence to cause Dr. Forson to be held liable for corruption and causing financial loss to the state, especially causing financial loss to the state. That the elements of causing financial loss to the state are in the 2003 landmark case of Republic and Ibrahim, and also the case of Chachuchi Kata in the Republic, where subsequently in the end, the court held that it didn't cause financial loss to the state, right? And the time that the act was done was committed before the law was passed. But in the Ibrahim case, the court held him liable for causing financial loss to the state. So it explained it, and I explained certain fundamental principle in relation to that and in relation to the public office. So it has been, uploaded onto the Google Drive. And then I explained the office of the special prosecutor, because there's likely to be a question dealing with the office of the special prosecutor, corruption-related offenses, and the distinction between the office of the special prosecutor and Yoku. So I addressed this particular question in full, and then I uploaded it on the Google Drive. So there are a number of questions and answers, right, that have been uploaded onto the Google Drive. Do you get it? To address these particular matters. So we have corruption, we have the office, especially the trending matters. So corruption, the office of the special prosecutor, etc. You find those ones in there. So we treated the mock exams where I took you through how to address these particular questions, if you remember. So more or less, right, all the answers have been uploaded. So you just need to have access to it. So basically, I treated a question that dealt with the matter of corruption, corruption of a public officer, Yoku, the distinction between causing financial loss to the state, corruption-related offenses, the purpose of such Yoku, and the office of the special prosecutor, because Yoku is dealing with what certain matters, right? Yoku is dealing with certain matters. So we can't have enough time to go through it, right? And I also treated chieftaincy and citizenship. So those are the last two topics that I just want to touch on a bit. But then it's almost 10, so I don't know how to go about it. But let's see whether we can touch on citizenship. I hope you got it. Let's see whether we can touch on citizenship. So I've answered a lot of mock, and I've even solved over 100 random questions, past questions on these topics, especially constitutional law, because constitutional law is obviously coming. Sometimes they can even bring 2 questions on constitutional law. So for all the topics I've treated, nature and scope, constitutional supremacy, constitutional enforcement, constitutionalism, rule of law, separation of powers, natural justice, constitutional review, the 1992 Constitution, Coups and Revolutions, citizenship, chieftaincy, commissions of inquiry, compulsory acquisition, the executive, the legislature, the judiciary, right, human rights, the general notes, and then the answers to past questions, right? I placed it on the Google Drive. I hope you got it. I placed it on the Google Drive. So you can have a look at that. So there are a lot of questions you see and answers you see in there. Do you get it? So let me just put the details in there. So I think with reference to the time, because we've almost done 4 hours, right? The citizenship and the chieftaincy, I've uploaded the drive, the materials in relation to that. But basically, you need to explain. Let me just share the Google Drive link. Just a moment. All right. So I'll share the link and I'll share the page. So we'll be having a lot of discussions and answering past questions, especially with the legis team, right? We'll be answering all the past questions. And then we've decided to create a number of relevant questions that are based on the trending matters. And then getting more or less the relevant authorities in relation to that. So let me just wrap it up here. Right, everything has been treated apart from 1 or 2 topics like chieftaincy and citizenship. There's a reason I excluded that because they are quite detailed and all. So you can just have your own personal review of it, relying on the Google Drive. And I've already solved hundreds of questions on these particular matters. And it's not only constitutional law, it is criminal law, it is tort law, it is land law, right? Immovable property law, that's land law, basically. Then we also have Ghana legal system, especially the matter dealing with sources of law. There's a common approach that students use that's usually deemed to be wrong. So we've corrected that approach and then we've uploaded that particular material. I hope you got it right. So more or less, if you want to get the background, because the most important thing is to create and build the structure of your authorities. So if you want to get that particular background, right, you need to know not only have knowledge of the law, but know how to build those particular authorities. I hope you got it. So in that sense, I think we can wrap it up here. I'll just share the link to the Google Drive, and I'll share the link to the entrance exams WhatsApp group. I think it has 820 members. So what we are going to do is that back to back, we will be solving past questions and uploading it on the Drive.
Senior,
we are basically done.
please, are we supposed to make payments to be able to access the Google
I think you
Drive?
just have to tap it. So just tap the link and an email will be sent. So we address it.
But it's
Don't worry.
asking for access.
I'll take the
Yeah,
I'll
so
take
I've
the
been
link
teaching the
again
entire
from.
time. If you've noticed, though, I've been teaching the entire time. So I've been on and
Oh,
on.
Access is 5,000 CDs.
okay, thank you.
All right.
That's it. So I'll take the link from you and share. So before we go, thank you very much, Senior Seth, for today. Our SRC president is on, so I'll give him the opportunity to share the closing remarks with us. So Nana, please, if you are here, kindly share the closing remarks with us.
So I can mute, right? Or
Yes, please. Yes,
all
please.
right.
You
So
can.
let me just.
Senior, today they export them.
Are we done?
Yes, because of the time element, I can't go beyond 10. So I've uploaded all the answers to each and every particular topic, and then I've been told to our speaker. I've been told our leader is about to address it. So I'm just waiting on that.
Colleagues, good evening. My name is Nano Pokuware and I'm the SRC president. And I'm delighted that so many of you were able to join us for the free Makola entrance exam preparation classes. I trust that these sessions were fruitful and contributed meaningfully to your readiness for the upcoming events. On behalf of the SLC, I wish you the very best as you prepare to write. We look forward to welcoming you to the Ghana School of Law in October. And our sincere appreciation goes to all our tutors who made this Makola entrance preparation a success. I want to also thank the organizing secretary, the general secretary, and everybody involved in making sure that this Zoom classes was a smooth process. I also want to take some time to just debunk all the, I know many of you have seen the articles online and so on. It's false, it's fake news, it's a hoax. I just want to take some time to just clear that off. Nobody has asked me to resign whatsoever. So that has been cleared. I'm looking forward to all of you. We are ready to work for you. One thing I can promise you is that this administration is going to be for you guys. Your issues will be solved within the shortest possible time. Anything you want, feel free to contact the secretary or any SRC executive. We'll be more than grateful to assist you in whatever you need. Thank you so much, everybody. All the best, and God be with you. Thank you.
Thank you.
Thank you. But let's leave the platform
We're
live.
grateful,
Let's leave
Mr.
the platform
President.
live.
Thank you.
Thank you very much.
President is
Thank you.
Thank you.
Your
Bless
Excellency.
you all so much.
But we can end with a prayer. I don't think so.
Nanaba, we are waiting for you.
Well, thank you very much. We have come to the end of the meeting. So do have a wonderful day, and I wish you all the very best.